अरे పెట్టిపోయి ఇక్కడ పోయింది ఐడి ఐడి స్టార్ట్ వీడియో అరే అది పెట్టినావు మళ్ళీ అక్కడ పోయినావు
tomorrow.
ఈ రెండు పెట్టుకుంటే ప్రాబ్లమే స్టార్ట్ వీడియో చెయ్యి అన్మ్యూట్ చెయ్యి
Kale, madam. Tomorrow. Yes, it will come tomorrow.
సౌండ్ పెట్టి సౌండ్
All benches at 2:30, no? Only 2:30. Okay.
Page wise mention, page number 1, item number 1.
పేజ్ నెంబర్ 6 ఐటమ్ నెంబర్ 16 విరాట్
Page number 3, item number 7.
ఐటమ్ నెంబర్ 16 ఐటమ్ నెంబర్ 16 విరాట్ 16
Page number 4, item number 57.
ఐటమ్ నెంబర్ 1 మీట్ కొట్టు
Who are you?
యు లార్డ్షిప్ మేక్ ఐటమ్ నెంబర్ 16 విరాట్
Post after 2 weeks. Next. Don't know anything. Will not print anything. You must go and pursue with that. 2 weeks. 2 weeks, right?
Item 40 minutes.
That's
After 2 weeks.
item number?
40.
16 విరాట్
2 weeks, right?
ఐటమ్ 16 విరాట్ 16
Page number 5, item number 42.
What's that?
Yes.
2007 matter. Huh? 2 weeks.
Page number 6, item number.
You are appearing for? No, that is not the case. 65 is not that. Okay. Post after 2 weeks, right?
యు లార్డ్షిప్
But
ఐటమ్
2008,
16
madam. What case? Post after 2 weeks. Next. 52. You are appearing for? What's your name?
శ్రీనివాసమూర్తి మేడం శ్రీనివాసమూర్తి
Post after 2 weeks. Okay. Post after you are appearing for? 2 weeks, right? One minute. Let the list be over. No?
Page number 8, item number 83 to 97. Page number 9, 98 to 1.
Informed other side. 2 weeks. What is this case? Then argue the case. 2 weeks, right? Yes. Counsel for the petitioner has informed the late Deputy Solicitor General has informed the court that the petition has become infructuous. In view of the same, it is dismissed as infructuous.
The complaint set number 2 is Satyanarayana law, showed of disclosure.
2.2 on 18. I'm about this one, it is very other than.
Yes. Who is appearing for the government? Have you submitted, one minute, have you submitted the proposals to the government? Then what happened? Who is appearing for the government? First after 2 weeks.
Take please minutes.
Just to inform, we will not direct anything. Yes.
Because this is a CRP directed against an order passed by the lower court, that is, the 26th additional chief judge, city civil court. There are two principal grounds, on which this CRP has been filed. Under the Arbitration Act, once the parties have approached one court, they have to approach the same court subsequently. This is the principle in section 42 of the Arbitration Act. If your lordships kindly look at section 42.
What, 1 minute, sir. Section 34 appeal or?
No, this is an appeal with the file under section 37 against an order passed by the arbitrators under 17. 17 is a power which, would you lordship kindly have a look at section 17. 17 is a power given to the arbitrators to pass interim
Yes.
directions.
Yes.
Section 9 is the power given to the civil court to pass interim directions. Your lordship,
Pending appointment, pending adjudication by an arbitrator.
my lord, yes. Now, once the arbitral tribunal is constituted, the arbitral tribunal itself can pass an interim order under section 17.
Correct.
In the present case, the arbitral tribunal comprises of an honorable Supreme Court retired judge, a judge of our High Court, and another gentleman. And my lords, they pass an interim award against which the respondent approaches the civil court. Before that, may I just show to your lordship what section 42 provides for?
Then what did the civil court 34 did against interim order?
My lords, this very party had earlier approached the commercial court because this is a commercial dispute.
Correct.
Now, my lords, he goes to the regular civil judge.
Right, then?
The regular civil judge does not have jurisdiction.
Then what did he do?
He has suspended the order of the learned arbitrators without notice. And when a well-reasoned order of the arbitrators,
Earlier, who has approached the commercial court?
both of us have approached, both parties have approached the commercial court. And also in the...
What happened to that commercial court litigation?
That's pending. That commercial court litigation is pending. That is on a different point, my lords. Now, please have a look at section 42. My lords have it.
Sir, what's the interim direction?
Interim direction is for deposit of certain amount of money and furnish of bank guarantee. He goes and takes an extra
How much?
30 crores.
They got notice.
But let's kindly appreciate this. There is one more.
Sir, even if we suspend that,
Yes.
they'll not comply, no? Until they come and
But let's-
contest. One minute, just listen.
What I-
Just listen.
Yeah.
Even if we suspend that civil court order, suspending interlocutory order passed by the arbitrators, even if we suspend that, they'll not comply, they'll come and contest this case, no? Then we can decide the main case itself, right?
This-
Saying that they could not have approached a regular court in view of this 42, right?
Correct. 42 and one more ground is,
Right, sir, that is all at the time of hearing other side, not now.
just I'll make one more small submission.
You may be saying 101 things, sir. We are in agreement with you, but what to do? We cannot do anything at this
There
point
is a
of time.
direct decision of our High Court.
Correct, sir. Can we set aside that? Please answer that
I'm
without
seeking
hearing.
a suspension. my lords.
No, no. Even if we suspend, they'll not comply, no? Because
Well,
they
it's,
come-
then I can work out my remedies.
okay, then just take out notice and we can decide the main CMA itself, the CRP itself, right?
But there is urgency because
You take out notice, the moment it is served, you come back and make a request.
But kindly permit me to take
Yes,
out
that
personal
is always
notice
so.
and kindly
That-
put it for next week, my lord, sometime.
Any notice has to be necessarily 2 weeks. If you can serve it before that, you can come in always. Have you heard anything, notice of 1 week? I don't think so. Correct? Notice before admission. Post after 2
In this
weeks.
case, I have not even been put on notice and the lower court has granted an order.
That is lower court, they can do anything. But when it comes to high court, we cannot. Right? Thank you. We have to follow the law. Right? Notice before admission, post after 2 weeks, counsel for the petitioner is permitted to take out notice on the respondents. Right? Petitioner is a what did the tribunal do? Dismissed. Naturally. No, 1 minute. On what ground you are challenging the transfer? Legal ground. Huh? You don't have anything. Yes.
4 years of service. Respondent is saying the counter is the junior most in the Hyderabad office.
Maybe.
Only senior most who is having long length of standing in the station should be transferred. Here, he taken the plea that I am the junior. There is no all India seniority matter. Now the Jabalpur nearby station.
So you mean to say when only when seniority list is prepared they can transfer you? That's a legal argument.
The other seniors working in the end of service. And it is not that nearby there are other stations. Jabalpur, they can accommodate others here in that place. Because now they say there is one.
You were successful in dragging the issue for 6 months, maybe more than that. You were transferred in April. By virtue of interim order, you continued for another 6 months, correct? Sorry, sir. We will permit you to submit a representation. It's up to you. This writ petition is filed, agreed with the orders passed by the Central Administrative Tribunal in OA number.
This is where it is drivers are working.
You want any other place?
Tuning means from Hyderabad itself is even though they have other people working in various places itself, they have not disturbed them. And here, I am only, this is the table shows, persons working in various places, excessively. In Bengaluru, only one vehicle is there, 3 people are working.
Jabalpur comes under South Central Railway, madam.
Mine safety.
One minute. South Central Zone, okay. Right. Two vehicles, 3 drivers in Hyderabad.
Now, one vehicle.
Jabalpur, 1 driver, no driver. 1 vehicle, no driver.
Accident is 4, one person retired. Vehicles, they declared one vehicle, they declared condemned matter. That's why now they say there are 2 vehicles. Well, their vehicles, 4 directors, 4 vehicles are there. But because one vehicle is condemned.
Okay. Writ petition is filed. Amat is called. Allow us to dictate the order, sir, please. Right,
This only one certain matter. See the station by how there was a working in there except another place.
No, we cannot. Writ petition is filed, agreed with orders passed by the Central Administrative Tribunal in OA number 254 of 2023 dated 17/10/2023. Heard K. Sudhakar Reddy, counsel for the petitioner, and Meera Malakunde.
5. Starting with reason.
There are two petitions. One is non delay petition.
How much is the delay?
There is no submission of the
Representation, how much? 52 days delay in representation condoned.
because in a resubmission.
1 minute, 1 minute. IA 1 of 2023, for the reason stated therein it is ordered. What is the stay you are asking? What is the stay? Stay application.
There are multiple applications because there is resubmitted payment again.
That we have condoned, sir. Forget about that. What is a suit? What is a, sir, what is a suit? Suit for?
Suit,
You have filed a suit for what?
suit is against this initial. This is an appeal by the defendant.
Recovery of, you wanted recovery.
And defendant
Suit is decreed, the suit is decreed against you.
yes.
Take out notice. Take out notice. Or we'll say that subject to condition you deposit half of the amount.
Here one is there.
1 minute, just listen, sir. 1 minute, sir. Suit is decreed for an amount of rupees 29,21,583. You deposit 50%, will grant your stay.
He eroded its capital.
Maybe, sir, just will grant you stay provided you deposit 50% of the amount. Will you do that?
I am on conditional argument. He has to, because capital of the.
Money decree of 50%, generally stay. Okay. There will be stay of the orders passed by the 9th additional chief judge, Hyderabad. Right, next.
Number 6 is Malayalam.
Extending interim order in spite of.
1 minute.
Normally, first seasoner will try to accommodate for the persons.
But the difficulty is, it looks really inhuman if somebody is standing. Right. Yes, sir. What is the case?
Extending interim order in spite of informing the trial court that the plaintiffs have obtained for the interim order.
When it was granted? When it was granted?
We have filed counsel informing the court that.
Take out notice, we dispose of the CMA. Yes. Notice before admission, post after 2. Notice before admission, post after 2 weeks. Counsel for the appellant is permitted to take out notice on the respondents post after 2 weeks. Next.
Item number 7 to 9, P.R. Prabhakar and Damodar Reddy versus 1.
Yes. Yes. Yes, sir. Uh,
I did not make it. Maybe it will be raised there.
yes, sir.
Sequence of events for the lot.
1 minute. Yesterday, we stopped somewhere. 8/2/2017 writ petitions were dismissed with a observation that interim orders have been complied. Then you filed a review, writ petitions were restored. So, correct. There is only a history, but that has no legal sanctity. Right, right. Narration. Senior, it's like this. Too many synopses also may make us confused.
But it tallies with the same. But no permanent, see, I
Oh.
will not to go through this.
Oh.
The dates and events have given it in the date wise sequence so that it will terminate for you.
That's it. We have followed. No, not like that. Not like that. We have followed one set of arguments with date wise. Then we have improved that by way of saying that writ petitions were originally dismissed consequent upon closure of the SLPs. Then you have restored the writ petitions. Again, it is back to square one. It is
Paper, my friend has-
fair enough. Correct.
I did not defend my paper.
Right.
Otherwise, they'll.
Right. So proceed.
I will not trouble you.
No question of trouble. Just try to understand. No, page number 169 and 238. Writ petitions have been restored. Your reviews are allowed, right? Right. That's all. Proceed from there. Any legal argument, please advance.
Now I come back to the
Oh.
submission.
Oh.
Now that GOMS number 28. which is
Yes.
the-
Yes.
my lordship certainly can say something. But they said-
ये छोटा बुक है ना बट वो इतना छोटा है इतना बड़ा है
that the reason for issuing the GO, whether it would be sustainable or not, is it?
करेक्ट
But the Royal Lordship certainly page 42.
Manjushri is referred to larger than constitution. Manjushri is referred to larger bench, constitution bench.
But there is no. Manjushri may not come into picture, but if I were to demonstrate to the Lordship why this GO 2018.
Okay.
Page 40.
Page?
Page GO 28. Because it is only interaction between and how to GO 28 is. That eclipse is over would be my assumption.
Okay. 28 is in the main book. 42, right?
Yes, sir. Balu.
Yes, sir.
Paragraph 4.
No.
The reference to second direct recruitment application goes to the.
Para 2 you are reading, sir. Para 2 is like this, sir.
Page 42, sir.
Yes, 42.
The reference second year.
Ah.
That's a GO 165.
Yes.
Then in the reference 4 to 5 to 9 data.
Hmm.
The education act program has been amendment to this. 2008, excluding the second level, basing on specification from the teachers association, public representatives and applicants for the post of teachers.
Hmm.
Then after the publication of the notification, it is reported that a number of teachers I will not talk about it. Then under the above facts, the government by keeping into overriding consideration, offering the best possible teaching to the students, both in terms of content, including basic knowledge and quality, in consultation with expert and expert was concerned, include the sources. So, decided to include modern subject specialization also in the required qualifications, apart from making other amendments, keeping in mind of special subjects. Yeah, government appropriately the matter have accordingly decided to issue appropriate amendments to rule 16 below 151 dated for it in the rule. What is the rules they have described? We draw you not to 7 and page 45.
Yes, rule 7, rule 7. They have amended method of recruitment. No, selection. Oh. Oh.
Seven, the following provision shall be added daily, provided that 30% of the secondary grade teacher posts are reserved.
No, what is rule 7? We must look into 161. Where is 161? Oh. 161 of the same book.
Rule 7, you are to get it. Page number something 3.
Yes.
Notification of vacancy.
It should have been method of selection. It should have been amended, not method of notification of vacancy.
Vacancies, how we understand.
No, if they wanted to amend, method of recruitment rule 3 should have been amended instead of notification. That is also fundamentally incorrect. Kana? Yes. How can notification be when method of recruitment says?
Lord, as long as the power is available,
So you can amend
we
anything.
should not,
Irrelevant rule also you can amend.
not irrelevant. But what I respectfully submit, your lordship, this will not go to the root of the matter is my respectful submission. It is, this objection is more in the form of a technical objection.
The method of recruitment gives power for you to recruit people from different
Sources,
Sources
including percentage also.
percentage also.
My
So
lord,
that should have been done instead of notification. As long as method of recruitment is not altered, you could not have. Okay, that's a legal point. Okay, 1 minute. Rule 3 is of 161. It's method of recruitment. What does method of recruitment says?
According to the qualifications and the post. 26.
Method of recruitment, they have prescribed the procedure. That is also incorrect. They should have said method of recruitment is to be made from inter DED degree BED. That should have been there instead of
Is both are eligible.
where is eligibility?
Terms of the post,
161,
29.
29. That is forming part of qualifications. Huh? One minute, sir. Yes, we have seen, yes. Yes, sir.
Election procedure, there is no change.
Hmm.
But vacancies, they wanted to segregate compartmentally, 30% and 70%.
So this was challenged by you, 36. That was dismissed.
Just make sure you are-
No, no. This originally you challenged, that was dismissed. You came here, right, right. OA, there is OA 36.
They just draw your it's 45.
Yes.
The rules, I it was only 30%. Then next year, the above provision is subject to the final outcome in the case pending with the Honorable High Court and Supreme Court.
Correct.
If this subject to outcome is now is in our favor, this GO would not be up. Therefore, the selection has to be done as per the GO 161.
Correct.
Therefore, the Manjula Bashmi also may not come into.
One minute.
If I were to demonstrate and that was demonstrated after, that this judgments of the High Court and Supreme Court are in our.
1 minute, sir. They issued 120. What is 128? Just okay, just no, GOMS number 128, 30/12/2008. They wanted to revert back or something. Same thing.
28. Sorry. They wanted to revert back.
After 28.
You were the most. It was 39.
Yes, yes. Then that was subject matter of some OAs. That is OA number.
And there was a stay granted by the driver. Repeated fight.
Repetition is confirming that. What happened to those OAs which were filed before tribunal challenging that 62? Any idea?
Yes, sir. I searched for the website, my lord, but I could not any details about this, whether that matter is transferred to the honorable court or not. But the petition is against interim matters passed in that OA. OA is pending. It
Correct.
is not transferred, my lord, so far as my investigation is concerned.
So 62 was withdrawn and another GO was issued.
No,
What is that GO? Was issued in your favor.
you were 20.
That was kept in abeyance.
Oh.
Then they proceeded in terms of the.
No. 62 is issued. So 27 is issued. 27 is issued. Agreeing with your contentions. That was subject matter of OA. Then interim order, High Court writ petition. Then 62. Para 13 of that particular 141 says 62 is subject to outcome of petitions which are pending. Correct? Right. So 28 is also subject to outcome of cases and also 62 also.
Yes.
Correct. So because of those clauses in para 13 of 62, you say even if the writ petitions are allowed, they must fall back on original notification but not on 28 or not 62, right? Same thing, no? Right.
But that was clarified by the Istanbul court,
Uh.
page 164.
Saying what?
That is.
Inka clarification, I mean, when they themselves are coming forward and saying that everything will be subject to outcome of litigation.
Fallen back. That is what the
161, huh?
164.
Oh. That is, these cases are arising out of what?
Most. paragraph.
Okay, now we are hearing how many writ petitions are pending on this subject? Only 3.
Four page. What this honorable court recorded is that even has now restored back to the original position.
Okay, legal argument చెప్పండి. Legal contentions. How many going around round and round I think. Yeah,
Multiplicity of issues have come up.
correct,
Now ultimately the original notification revives.
correct.
Once it revives, then they have to undertake the entire exercise.
Correct.
Effort. At this stage, my responsibility is DO is not sustainable and it has to be set. In such a situation, what should be the course to be adopted by the?
What is the reference for a constitution bench by the Supreme Court about Manjushri? Whether rules of game can be changed or not changed? What is the query which was the reference order there Nundadi?
But
That is exactly the same point, my lord, which was now argued and reserved by the constitution bench.
Correct. What is the reference without knowing the reference? On
True,
to
I
what
don't-
extent it is referred? Whether
Whether-
the precise
whether-
point or some other point ante we did not because it
Direct, subject to correction, precisely the same point which the learned counsel are urging that rules of the game cannot be changed once it has started.
correct.
Is precisely the question, my lord, that fell for consideration before the constitution bench, which was argued, judgment is, my lord, awaited. Very same point. Whether it cannot, it can never be touched,
Right.
or it can be.
There's no difficulty in understanding, but until unless we see the reference must be something else, not this issue. Then that's the point.
My lord, to my knowledge, it is precisely the same point that was referred to the constitution bench.
Reference చూడాలి.
When it can be amended, to what extent it can be amended, it can never be amended at all.
No, the issue is how GO is better at the whether once notification is issued.
Even we have the
It's there in Sivananda. Petition was taken and the judgment was so. This was a constitution which followed the other making reference to the constitution mentioned earlier, the principal issue which has been addressed is whether it is open in law after a selection process is instituted to change the rules of the game midstream. This is that has been referred. This Subhash Chandra Marga really has said that you can, this was not brought to the notice. When the Manjushri was Manjushri,
Said it can change.
then it was referred. Already when I read. So Subhash Chandra Marga, it was for inquiry. This is the same raising of Sivananda. But here they went on legitimate expectation because this was the point which was argued before this court. So this has been left open by constitutional benches sitting in this. The midstream, Manjushri is 3 judges.
Manjushri will go at Premature because it is not taken into
Manjushri, Para 9 Manjushri yesterday was given.
which
Page 225.
Para 27 కదా Manjushri.
Yes, 26.
27.
Yeah.
Yes, yes, it is there. Even in this Shivananda.
There, my lord, Tej Prakash Pathak for the judgment, my lord, in this court said that.
Because Manjushri has not considered the Prakash Pathak.
Manjushri has not.
After Manjushri, Tej Prakash Pathak was there, and Subhash Marwa, etc., having not
Yes.
considered.
Yes.
They made a distinction.
No, Subhash Chandra Marwa was not considered in Manjushri.
In
Then they said, because Subhash Chandra Marwa took a different stand earlier. It was in 94.
That's the reason it was doubted.
Question that fell for consideration, which is happy to be looked into by the constitutional bench was whether a rule which is modified for the purpose of depriving eligibility stands on the same footing as a rule which modifies the selection criteria. This is exactly para 15 talks about. So eligibility not being modified, can I modify the selection criteria? For instance, if 30% graduation, everybody is eligible.
Supreme Court judgment is just a 1 week pending.
This is when taken longer time. The same day, reserve law. जल्दी दे दिया ये उसमें क्या होगा बोलते हैं अलग अलग देते हैं बस दिस इज यूनानिमस लेजिटिमेट एक्सपेक्टेशन
Very nice legitimate expectation. What's the right call? So, but the legitimate expectation will be different.
because the margin can argue different legitimate expectation.
Hello. Unknown competition also with legitimate expectation. Correct.
Procedure from substantive explanation.
अभी लिखना तो फिर का मैंने टाइम पे
Legitimacy of
the characteristic of what that means taking next time because they are expecting important subjects to be video. And national teacher council level here.
National Council for Teacher Education.
NCT, NCT, National Council for Teacher Education. Part of despite participation regulation of leading pretended on education. National NCT has prescribed the qualification of DED, right? BED has been deleted, I think, no?
Ultimately, I mean, not
But ultimately, the fact remains.
after 2011. That's why, my lord, Rajasthan school teachers matter, which went to Supreme Court very recently. They made a distinction. Some of those things which have been made after the 2011 amendment to the NCT stands on a different footing. That's why, my lord.
So, BED is removed now, as per NCT.
B.Ed for the purpose of classes 1 to 4. That's removed.
The scheme for the notification of gender. But that way, when you do a notification, so what's what is expectation is?
Yes, sir. Argue in the interest of justice. Okay, right. Yes, proceed, sir.
And of 14 and 15 difference made. But they may not come in the way because there is no change in the selection process. The methodology is 100% marks, 100 marks, and it's very secured in the written exam.
Yes.
Coming for issuing the appointment order, they said 30% selection will be reserved for the PA. That is not a difference which is being now made to the Congress.
And believe in 62.5%. 62%.
Yeah, that is right. Parliament, they could not fill up 70%, not 30%.
Still,
why they have to not fill up? Abhi apro question hai. Irrespective of all these things, Govind, 70% you could not fill up. 30% also you could not fill up. Why? And so many candidates falling under 30% are available. Why they could not be selected?
My lord, because of 70 and 30, my lord, it could not happen.
No.
30 is reserved exclusively for
No.
DED,
70 you intended to fill up with DED,
both DED and BED.
whatever it is. You could not fill up. 30 also you could not. 30 exclusively for
DED.
DED. That also you could not fill up, no sir. Then what is the explanation forthcoming in respect of 70% where they are also eligible? How many vacancies you could not fill up in 70%?
ఉందా మీ దగ్గర?
Andhra has undertaken that exercise.
Oh.
Are affected by this PO.
Yeah.
It's better. So there is no difficulty in super state of Andhra Pradesh is concerned.
No, whether it is Andhra Pradesh or Telangana. No, 1 minute. Whether it is Andhra or Telangana. Recruitment was done by Andhra Pradesh, composite state. So question you must answer is that 70%, they are all forming part of 70%. When they are eligible, why they were not considered? I can understand if 70% is filled up and these persons could not get selected because of 30% exclusively reserved for DED, then this issue would arise, no sir. But why 70 could not be filled up when these persons are qualified is a question.
Lord, that perhaps I may have to get instructions, my lord. Immediately I may not be able to.
Where are the details? 70% in all, how many? Last time I think in this synopsis somebody has given 29,000 or some 30,000 posts we have notified.
Page 155, my lord.
Yes. But if you take up the smaller volume of page over
Now come back to
constituted a expert committee now guide me to the entire thing.
Telangana state government has filed an affidavit saying that 1,815 vacancies were not filled. 1442 vacancies of 30% and 373 vacancies of 70%.
Yes.
That is on,
One-
that is on. AP government appointed 2,193 candidates.
yes, sorry, और एक है मैम. Okay, दो कॉपी नहीं है. Okay. Yeah, everything. Basically, last time this was a great.
But I will give you the second condition. If even without you have to put the zero, it's dissension, or some many consequences. But that is possible. This man, I think that to take the consideration in level practice. Where the selections were made pending with executions and appointments were made. Supreme Court taken that factor into consideration and resolve the consequential relief, how it could be modulated. Where Royal Lordship says,
One need not go into that. Once, 1 minute. Once it is set aside, entire selection process has to be redrawn.
keeping in view that others are also
Right.
Indian step distribution because the rights of appointment were and basically required was declared by the commission in accordance with the directions of the state government. Pursuant to the international high court, the appointment orders contained in the terms of the appointment should be subject to the result of the execution filed by the expert. Since the applicant has succeeded, the respondent's appointment liability is assigned. The respondents have been working for a period of about 15 years. It would cause their hardship to come if their appointment is quashed, and they are directed to vacate the office which they have been holding during all these years. At the same time, the appellants have been wrongly denied their right to the post of particular. Having resolved these facts and circumstances, we are of the opinion that it would be expedient in the interest of the justice.
That is 141. That is 141.
Why I am trying to, I will read this one, then I will say what the exercise they have undertaken, and we are also happy with that procedure being adopted. Not to influence the respondent's appointment, but at the same time, steps should be taken to ensure the appellant's right to the post of particular. In this view, we direct the state government to appoint appellants on the post of particular. But if no meetings are available, the state government will create supervisory post for appointing the appellant against this. We further direct the for the purpose of seniority, appellant should be fixed below the last candidate appointed. So and so, but they will not be entitled to any benefits. The appellant will be entitled to promotion if otherwise found suitable.
Right.
Thereby resolving the issue without affecting any other aspect. And this exercise is not partly has been undertaken by the state of Andhra Pradesh. It should be my-
Correct, sir. Having regard to the facts and circumstances and 141. Okay? Who want to marry?
But this is now undertaken by the state government.
Yes, it will. AK, 2014. AK saidara. Good luck. Taking same judgments. So therefore, already been promoted to class or by the court director to take more vacancies, so the state government will create a sort of. Right.
I am only trying to make my submission that equitable order could have been passed by.
Yes.
Then
We have passed equitable order. That was not correct. Appreciated. Right. Right. Next.
Then what is the exercise undertaken by the government would also be relevant to be brought to your attention. What the state government has done is they constituted a company, identified the personnel who will be inducted into this post in the event of restoring the original procedure of action. They identified 2193 posts are available.
In that case. In that. Who has identified?
One part of the state, that is state of Andhra Pradesh.
Okay.
Saying that these are all the persons who will be.
Where is that exercise of state of Andhra Pradesh?
That is at page 130 of the additional small.
Yesterday it was thin. Now it has become small.
Language, English language.
AP government has done that exercise. Right? 130. Right.
Page 130.
Right.
They identify the person also who are entitled to be appointed.
Some 2,900 something.
193. now injected with terms and conditions in terms of the notification.
Right. That's all, sir.
What they have undertaken, if they give a voluntary basis or a contract basis on year to year basis, they pay, initially they paid only 10 months salary per year, and now they are now extended to 11 months. But that procedure not is only a temporary phase would be marriage provision, because once
So AP government candidates are also before this court.
majority are before you.
So everybody is working on contract basis.
By virtue of this GO 39, subject to the outcome of the recruitment.
39 dated.
Dated 21st June 2021.
Yes. Yes, sir. We'll consider.
Therefore, this 2193, insofar as those districts now falling in the state of Andhra Pradesh, they are entitled to be treated as a regular teachers with consequential benefits.
Right.
Thereby, we will not be disturbing persons who have been recruited.
As it was done in the case of
They were-
Devan Katti. Right.
That is my judgment.
Right, sir.
Because I am not representing any candidate belonging to the state of Telangana.
Correct.
Sir, in addition to what my learned saying, actually I have two additional statements which perhaps will have to be considered in our favor. Okay, first and foremost, legal principle is, my lord, that the recruitment rule will be governing the field and notification will be governing the field of selection. Now, in the present case, my lord, my learned senior friend has taken your lordship through GO 95, which are the recruitment rules for the selection, which says that this is the mechanism by which you will have to fill up the vacancies and these are the qualifications.
95 or 96, sir? Right. Not 95. Right.
GO 161, which is a GO for the purpose of procedure, also talks in the same language of the qualification.
Correct.
Now, and there the notification which was given by the respondent, my lord, pursuant to 161, also reiterates. So
Right.
therefore, the selection will have to be strictly done in accordance with the
One thing, Shiva, 96 is original rule.
Yes, 2005.
That is, procedure is 161. They should have amended 96.
And subsequent, they should have a very improvement. As long as the recruitment rule, your lordships are aware, quota and rota rules are prescribed in the recruitment rule. Only that will have to be the basis for issuance of a notification and eventual selection.
1 minute. First submission of Shiva is quota and rota. ROTA.
This one, rotation and quota, this is how they call it, quota rota.
We don't know. We are learning. Right. Quota and
We have been used to use quota rota rule rather than saying quota and rotation. Quota and rota is normally prescribed in the recruitment rule.
recruitment rule is 96. Without amending that, they have amended procedure.
Notification was issued exactly in consonance with the recruitment rule.
161 is the genesis of 96.
And procedure for appointment is what is detailed there to make it explicit what was not otherwise. And perhaps you have transparency. Perhaps.
There are a number of judgments of quota rota rules. What should be, how it should be.
Whether that is there or not in this. Presently, I am not saying whether 30% could have been imposed, not for nanosecond. What I am trying to say is, when a notification is prescribed and issued in accordance with the recruitment rule, any tinkering and tampering will and can have to be done only when the recruitment rule is altered, not otherwise. As of now, they have not done it. So therefore, my lord, the very exercise of giving a prescription is untenable.
Right.
Then the second follow-up contention from this would be, my lord, we have been heard to say, I have power for amending whatever portion I want. Kindly see the untenability of this for 1 minute. Whether it is 3 method of recruitment, 7 which they have amended, or this is liable to be amended para 16, which talks of reservation, etc. which you will have to amend. Also, para 16 talks of selection list,
16 of what?
161, page 35.
Big or thin? Big.
Convenience volume, I don't have to trouble your lordship with a smaller volume at all.
Right.
So it will be a big volume.
30?
Page 35, rule 16.
Yes.
Preparation of select list, reservations are contemplated under sub-rule 2 thereof, which talks of rule 22. So the apt place where you have to incorporate, assuming you can incorporate, should have been here.
Preparation of selection.
Selection list,
Uh.
where rule 22 reservation is contemplated, the quota should have been here. What draws out from that would be a serious non-application of mind, as my learned senior friend Mr. Vidyasagar read to your lordship, there is a pressure from a group, give an order, and come to this court and give a justification that I have a power. If I have power is the only mechanism for justifying your order, courts have been holding well that itself is arbitrary. We have been heard to say only that.
This 35 is forming part of
61.
161. Right.
This is the third first submission. We will go to GO 42. It uses two expressions. Page 42 is GO 28.
Oh.
Page number 43,
Hmm.
where the amendments start.
Hmm.
Your lordship would see the first portion which reads like this. In the said rules,
Hmm.
in rule 2, my lord's got that.
Yes.
The rule, the following shall be substituted. So, this is substituting something which is existing at the relevant point of time in 161. Now, kindly juxtapose this with the language at page 45.
No.
7.
What is being substituted earlier? No, 1 minute. Rule 2 refers to district educational officer of the concern. Earlier 161 was consisting of what? Rule 2.
Rule 2, 161, rule 2 would be at page number 25. District education officer is at 25 itself appointing authority.
Yes.
This supports an amendment saying that we substitute this. So all the things, because they said we have given this, etc., the qualifications are also substituted.
Oh.
For note 2, I am showing your lordship page 44.
Oh.
Number 3, which says for note 2 under rule 4, the following shall be substituted.
Oh.
Then we have the crucial amendment at page number 45, with which we are concerned. Kindly see what does it say. Rule 7, the following provisos shall be added.
Hmm.
Meaning thereby, it was never the intention of the rule maker, assuming that he could have done this, that it will have a prospective effect because this is added on and from 29/1/2009.
1 minute. So substitution is from the date of inception.
And it's not as though that the legislator is not aware of two different phrases. He knows that he will have to substitute it, and he knows that he has to add it. If you add it, it will be prospective. If you substitute it, perhaps there is a theory saying that it dates back to the date of original order. Consequently, this amendment can never form part of the selection which took place now. On this solitary ground, the GO 28 will have to be, what is it, set aside.
Okay, what is the statutory interpretation of adding the word and all those things? If it is added, it is prospective, it should not be understood as with retrospective effect.
Interpretation is the document itself.
No, that is right. That is too basic. And we are law చూపించాలి దాంట్లో. Right.
Says with a purpose.
Right. There should be some support of some authority on that for your argument. You can't.
Interpretation.
అది ఎక్కడ ఉంది? ఏడుంది ఆ బుక్ ఏడుంది మరి?
I'll blame them.
No. What is?
I'll blame them.
The bench is supposed to be ignorant. You are learned counsels, you must educate us, right? What is?
I'll place that man.
I'll present, we'll adjourn then. If you want to place it, we'll adjourn then.
suffer adjournment for this.
Or it is not available. Add it here. Add it, it is perfectly substitution, it goes to the root cause. No doubt you raised a very interesting point, but there has to be some authority for this.
Before 415, I place the authority before your lordship. It doesn't need to suffer an adjournment. I'm assuming that it has to go. Anyhow, my learned friend for Telangana government will be asking the answer tomorrow. By then, it will be placed before your lordship.
We'll take, yes, well taken of that argument, right?
Next question would be, my lord. Next question would be,
There is an addition or subtraction in case of the same remains. That will also be the point of such a.
You just put it for me. Yes.
this was never the intention. And finally, my lord, the GO itself said that it is subject to final outcome of the litigation which is pending and which is pending as on date also. So nothing can turn out from this GO. One crucial factor is, my lord, this is not in consonance with the recruitment rule at all.
Correct.
So therefore, my lord, when the recruitment rule does not contemplate a subdivision between the same class which prescribes the qualification for BED, DED, question of yourself bifurcating it does not arise. This is one additional point which I want to bring into your lordship. Second crucial aspect, my lord, is this: the courts have been consistently holding, the latest being in 2023, that a notification which has been issued is virtually a statutory invitation for these people. Consequently, they have a right that their case should be considered in accordance with this notification, and any deviation therefrom, my lord, is violation of Article 14. This is what the Honorable Supreme Court says in a judgment represented, my lord, 2023, SEC online, page 167. The relevant paragraphs, the only paragraph numbers I give, my lord, is paragraph number 23 and 25.
1 minute, sir.
Yes.
What? Para?
23.
Read.
Yes, ma'am. Another unique feature of the present case is that selection committee has reduced the marks to facilitate the horizontal reservation by treating it as a vertical reservation, etc. Admittedly, the rules do not provide for such a reservation to be treated as a vertical one. Likewise, the rules do not fix any cut-off marks. An advertisement made pursuant to a notification binds the parties. It has got all the classes in the statutory prescriptions unless it becomes contrary to either rule or an act. A change, if any, can only be brought forth by way of an amending act and nothing else. Such an amendment, even if it is permissible, can be tested on the touchstone of Article 14 of the Constitution of India. It cannot be introduced to give an entry to a special reservation in a case where the right becomes accrued to a candidate under a policy decision reduced in the form of an advertisement. That's it. You have already given an advertisement saying that we will consider BED, DED. Now you are trying to give a horizontal reservation or whatever reservation and now trying to tinker and tamper with the advertisement without amending the base rule. This the court said you can't do. And then it finally said it has a statutory trapping. Even your notification has a statutory trapping because the notification is bound to be in consonance with the statutory rule. And finally, the court may have modified. I'm not on the modification part of it. And failure 25, it specifically says this. admittedly, in the case on hand, the appellants are entitled to get the respective courts as per the advertisement issued. The said advertisement has not been amended. It was sought to be modified on advice of the government, etc. Then fixing cutoff marks for a particular category has got a rationale behind it. Reducing it only for the purpose of providing employment to a particular category when others have already acquired some rights would be an affront to the Article 14 of the Constitution. This is precisely what I am reading before your lordship.
So 28 has been corrigendum kind of a thing was issued in the form of a press note.
Statement specification, if your lordships have seen, the death note might not, perhaps your lordships are seeing, page number 40, they have filed it along with the big book also. Page number 41 is perhaps what your lordships are looking into. Kindly juxtapose it with 46, where a notification was given by the Public Service Commission against this very thing. This is not what is there, and this is only a note put by the government. We do not even know whether it has been printed at all or not. Press note is given to all leading newspapers, etc. As it is a press note, it should not attract advertising charges. So to save advertising charges, they may have given it, whether it's formed a part of any press or not. If not, what is given here at all. She means it's given also, my lord. My main root argument saying that.
1 minute, 1 minute, 1 minute. Corrigendum ఇవ్వాలి కదండి notification కి ఇచ్చారా?
My lord, GO 28.
Correct.
GO means your lordships are aware, it would
Not
agree.
like that. Notification was issued saying that recruitment process will be 161.
Yes,
You have amended 161. Corrigendum ఇవ్వాలి కదా? ఇచ్చారా లేదా?
my lord, I may have to get, but 28,
This is Del Nageswara's judgment, my lord, saying that notification is by our Saxotank, we will have to abide by every condition. On the face of it, we don't need to get to that level also, my lord. It is because the rule itself is unsustainable, that puts the end of the entire thing. We have specifically pleaded before the tribunal saying that you have not notified it. This goes unrebutted. So presumption under law is when we have raised a ground that it is an admission. Therefore, we are proceeding on the basis that you have admitted that it was not publicized.
press note is informing GO 28. Prescribing. Please see, my lord. Kindly come to 43. The preamble of this notification. Preamble, my lord, it's very clear because my friend is trying to read about substitution and addition and trying to make a distinction that it comes from that date. Addition is from, kindly see the preamble at 43. In exercise of the powers conferred under 309 of the Constitution, read with so and so, Governor of Andhra Pradesh hereby makes the following amendments to the AP Direct Recruitment of so and so 161, dated 6/12/2008. So all the amendments that are made hereafter would give, my lord, would become effective from the date of issuance of 161, 6/12/2008 is my respectful submission. Ante this what I respectfully submit is, that is what I am trying to submit. By virtue of this 43, which I have read to your lordships, amendment issued to 161 dated 6/12/2008. These are all the amendments which would date back to retrospective also can be given, my lord, when it is specifically
Which
stated.
portion of 28 says it is going, being given in effect with retrospective effect? Please show us, no?
That is what I am reading.
Hmm.
Notification which says,
Hmm.
the governor of Andhra Pradesh hereby makes the following amendments to AP direct recruitment of posts of teachers scheme of selection rules 2008, issued in 161 dated 6/12/2008.
Correct.
So this amendments dates back to 6/12/2008,
We
which is
didn't get that, Akkada, which portion of 28 says so? Is the question we are asking.
this itself, my lord, should be understood
No, no.
as
Amendment will come with effect. Now, preamble. No, this is only one. This is only difficulty being faced by the government. This only shows the difficulties being.
As far as submissions on the legal aspect. Now, this court, my lord, if it comes to the conclusion and agrees with the petitioner, the consequence should be GO 28 will have to be set aside and the entire minor case will have to be redone.
Right, next.
Considering the fact that your lordships are thinking from a human perspective also, it's my duty to submit to your lordships on that aspect also, and only for that purpose I'm making the submission. Now the lordships are aware, out of the 70% vacancies, my lord, which have been filled in accordance with the merit list, may not warrant the tinkering and tampering even after your lordships are judgment, because they are bound to be filled up exclusively in accordance with the merit. So what remains would be this 30%. Only to drive home my point, let your lordship may permit to me to say this example to say that such a huge ramification may not arise at all.
The revision has to take place only in respect of 30%.
Both BED, DED. So in a given situation, if 71, 72, 73 in the merit list are BED, they may dispel the DED people or push them down. So virtually what happens is, the tail at the bottom, who did not even secure the rock bottom and they were appointed only because they were DED, only that segment may suffer. And it will not be a Herculean task for the government to do.
It's easy to present the case like that, but the amount of implementation when it comes to that, it runs to another 20, 30 years litigation.
Say this. Permit me to say this. Not for a moment saying that we can brush them aside, not for a nanosecond. It's a case where, my lord, yesterday I was trying to tell you and we were all trying to say, my lord, it's a problem which needs to be taken into consideration, not only the legal aspect, but also the human approach also, because of the fact that the matter took place for such a long period.
Any other legal point, your point?
This point, my lord, is for the purpose of mounting the relief. Your lordship may only have to say.
First, molding will come later. Molding will come later. Right. Right. Next.
Well, legal point would be only this, my lord. In view of these grounds which I
Right.
28 will have to go.
Any other counsel? Any other counsel on behalf of petitioners? Any other?
Ships. We are for the interveners and we are supporting the petitioners.
Yes, madam.
Here. Yes, I am on behalf of
Not
senior
able to hear
advocate.
you, madam.
Your lordship,
Not
Sorry.
able to hear. Please check your audio.
am I audible now?
Not able to hear you.
I have unmuted myself, your lordships.
What's your name and you are from which place? So that we'll have to note down
I'm
your
from
arguments
Supreme
also.
Court. I'm representing a senior
Not able to
advocate.
hear, please check your audio. Are you able to hear us? If you are able to hear us, lift your hand.
Yes,
Thank
I'm
you.
hearing you.
We are not able to hear you, that's the reason we are not raising our hand, right?
Your lordships, I have unmuted myself, but
We are not able to hear you, madam.
You are not audible, madam.
I'm trying, your lordships. I'm trying. Am I audible? What's the problem? I cannot.
Just log out and then again try to log in, madam.
Mat. Yes, your lordships. Log out करो नहीं आ पा रहा
फोन नंबर दिया तो व्हाट्सएप में बोल रहा వాట్సాప్ కాల్ రమ్మనండి కాల్ చేసి కడిగండి మీ ఫోన్
Only correct method. The correct method
yes madam okay what is the case madam
Mr. P.S. Patwalia, sir. I'm from
what is the senior's name
Mr. P.S. Patwalia, Paramjeet Singh Patwalia.
madam
Paramjeet Singh.
Paramjeet Singh Patwalia.
yes
Am I here?
yes very much senior counsel from Delhi
Supreme Court.
there is also Delhi only no
Yeah, that's.
thank you
Yes, your lordship. Yes, your lordship.
right
I'm starting my argument, your lordship.
yes
That the recruitment to a public service, I'm having authority over it, that recruitment to a public service should be held strictly in accordance with the terms of advertisement.
correct
And if it is not done so, your lordship, then it may lead to the entry of some ineligible candidates as well, your lordship. And it is very much apparent in the present case that some persons scoring even 4 marks, your lordship, they have been appointed under the proviso, under the amendment of GO number 28, by which they have been appointed, your lordship.
yes
Citation, if your lordship may write the citation.
yes
It is Yogesh Kumar versus Government of Entity of Delhi,
Yogesh
2003. Yogesh Kumar
yes
versus Government of Entity of Delhi, 2003, SCC 548.
government of Delhi
Yes, your lordship.
citation ma'am
3 SCC 548.
what SCC which year
3.
year madam
2003.
3.
page
3 SCC
oh,
548.
548 okay next which paragraph madam which paragraph para 8 okay next submission
Now, lordship,
oh.
am I audible?
Don't worry about that. Please argue the case. What is every time you are asking? Right.
Okay, your lordship. Now, your lordship, I'm coming to the root cause. Where was the amendment was made? Your lordship, there was a observation of the High Court.
Yes.
Just a second. Just a minute. Of the High Court that the dealing candidates must be given preference, Your Lordship. Earlier, in DSC 2006 cases,
What is the judgment of High Court?
that answer. Your Lordship, that is WP number 12800 of 2007.
128 of 128
00 of 2007.
dated
Dated 22 of December 2000.
how can it be 2007 writ petition, how can it be disposed of in 2006?
No, it was DSC. Your Lordship.
Date of 1 minute, madam. 1 minute, madam. 12800 of 2007 was disposed of when? Date. What is the date of that order?
Which was challenged before the Honorable High Court.
What is the tribunal OA? What is the tribunal OA?
That is 254
OA number
254
254 of 2006, dated
dated 22 of December 2006.
what did the tribunal do? What did the tribunal do?
Earlier there was GO number 96, which was challenged by
Correct, madam. 1 minute, madam. What did the tribunal do? It has allowed the case? 1 minute, madam.
the DA candidates. The tribunal allowed the case of the DA candidates, let alone the state of AP challenged the same before the Honorable High Court.
That was dismissed. That was dismissed or disposed of? Writ petition.
Your Lordship, but there was observation
Oh.
on page number 314 of the big Python petition, page number 314.
1 minute, madam. Okay, based upon this orders passed by tribunal in 254, preference should be given to DD candidates. The rule came to be amended. Am I right?
Right.
Right, thank you. Next legal point, madam. That is all history. What is the legal point you are saying? First is you said recruitment has been.
That is the legal point that the recruitment should be in cancellation.
Correct, that we have noted down.
Of the Honorable Apex Court, citing the SLP before therein and remanding back the matter to your Lordship. That was the very crux of the judgment of the Supreme Court, your Lordship.
Yeah. Where,
Supreme Court had guided. May I read the para of the
Supreme Court, right? Read, madam. Which one? Yes.
now starting for your Lordship must be having the Supreme Court order.
Yes, yes. Yes, we are having, madam.
Now starting from the second para, your Lordship.
Yes.
It reduced from the record that the state government at the first instance issued a notification dated 6/12/2008 prescribing the service conditions of various categories of posts in exercise of its power under provision to Article 309 of the Constitution of India. And simultaneously notification appointment of Region 2000 at the latest point of time pursuant to the advertisement number so and so.
Hmm.
Was also initiated. Now, on the second page, your Lordship, it further reveals that amendment was made by a subsequent government order number 28, dated 29th of January 2009, that too in exercise of its power under provision of Article 309 of the Constitution.
Yes. Yes. Where is the reference of 254, madam? Where is the reference of 254? OA 250. Where is the reference in 254? But but just now you said that
For the case of AP, there was no such direction in your lordship. There
okay.
there was no direction, in front direction to the state of his duty.
Right.
Amend the notice to amend any rule in respect of providing 30% quota candidates.
1 minute, madam. 1 minute, madam. Come back to page 42 of big volume. There is no reference of these cases filed by some of the DD candidates. So the question of you going to the root cause, all those things may not be necessary at all, right? It is only academic, right? Page UMS number 28, which is at page number 42. In the references, there is no reference of tribunal's order in OA number. 1 minute, just listen. Just 1 minute. There is no reference of OA number 254 nor High Court writ petition 12800 of 2007. So why you are arguing that, I don't know.
Candidates will be given exclusively a portion of.
Correct, we are aware of it. That is too basic, right? Everything, yes. I don't know why.
This option is only after observation.
There is, correct, there is no reference that 1 minute, just listen, 1 minute. 28 is not issued just because of observations made by the High Court. Had it been taken into account, it should have been reflected in the references referred in UMS number 28, right? Okay, right. Next, that could be incidental. That observations may be one of the reasons, but government has, in its wisdom, on its own. 1 minute, just listen. 1 minute, listen. At the request of some of the representations from DD candidates, that necessitated the state government to amend the rule. That's it. Okay, right. Next legal part.
Only made.
Please, 1 minute, madam. Other councils, I think, covered most of the issues. Please confine your argument to legal issues. If you want to add anything, I think you had the advantage of listening to some of the councils who have argued in the open court. The point, yes, any other legal point, please answer. Argue.
I want it that once the notification is very clear, the terms of notification, that is GO number 161.
Yes.
And that originates from the GO number 96, Your Lordship.
Correct. We understood that. It is only a repetition of argument. Any other legal point you want to raise, please raise. Other than what has been.
Now, GO number 28 persons, Your Lordship. What we had done. First, we did not implement the common merit test in terms of GO number 161, which is violated to the Article 21 of the Constitution, Your Lordship. At
How 21 is violated?
several number of candidates, that the figure is 4,650.
Okay. Okay. Any other legal point, madam?
The Supreme Court, as the intention of the Supreme Court is very clear to decide the validity of the GO number 28.
Everybody. Madam,
Decide the validity of.
thank you. Because it has demanded, that's the reason we are sitting here and hearing the case, right? Right. Yes, next.
And now, the state of government.
We have not done anything.
Serious repercussions have been caused. Actual jobs, which is also not be
Correct.
contractual job, which should not be allowed to conduct, Your Lordship.
If it is not allowed, you'll have to sit at home then. No?
Your Lordship,
Correct. 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 We'll consider.
If they will take
Very well, madam. We'll consider that point. Any other point, madam? Any other legal point?
No, Your Lordship, that has covered all the legal points.
Thank you, madam.
Your Lordship, as online and there is some kind of problem, so Your Lordship may allow to find written submission of limited page number.
Very well. Very well, madam. Very well. You can do that, madam. Yes. Any other?
As far as having a substitution method, we have a judgment rendered by this honorable court, a division bench, which was dealing with the relinquishment of promotion system. Under that that I placed before your last, where it dealt with what would be the impact of substitution thereon.
On the ground of legitimate expectation, when a notification is given, the applicants who come forward filling the applications have a legitimate expectation, and state in its virtue has to fulfill that legitimate expectation. Is it not binding on the state once a notification is given? No, no. Precisely, because the reasoning is because the concept of legitimate expectation stands on a different footing when compared to what is 28 and what is 26 and what is 27 and what is 161. Because
The impact is whether the subsequent notification will have any impact on the.
because legitimate expectation flows from the virtue that a right has been, in a way, has been given to them. Yes.
Credit should be given to my brother. Correct. If nobody has argued that case, that point, that is squarely covered by Shiva Dasan, I think.
Shivanandan,
Shivanand.
the Constitution bench judgment, it has very clearly said.
Para 252. Everybody missed. What is councils? That is the advantage of sitting with learned brother. Correct.
We also have benefits.
Yes. Yes. Everybody is over from the petitioners council. Yes, who is starting from AP or Telangana? AP older in age, I think you must start.
My lord, your lordship had asked a question about publication yesterday.
50. Yes.
Your lordship had asked a question yesterday about publication. That time I had to get information from my people.
Correct.
Barring that, if your lordship wants to come, my lord, answer with regard to the legal contentions and that.
Or else, do one thing. You adjourn the case to next Thursday or Wednesday, whichever is convenient. You have heard them.
Yes.
What are the lacunas you are there? You try to get those instructions. Anyhow, state of Telangana also wants to get instructions, revised instructions as to how they want to resolve. If at all they want to make an attempt to resolve, I don't know. If some instructions are forthcoming, it will be serving the cause in a better way instead of re-adjudicating again. Suppose last time when we delivered a pragmatic judgment, that was challenged as though they are not parties and all those things. Now, if they come forward with some suggestion, we can pin them down with their undertaking or with their consent or whatever it is. And one issue when it comes to state of Andhra Pradesh is concerned, no doubt you have resolved their issue to some extent of appointing them on contract basis. Now, next step is
Whether if 28 goes,
whatever it is.
my lord,
The question of paying wages, back wages, all those things ruled out. Only thing is you'll have to take a policy decision and regularize their services. Now that they are working from 2000, whatever it is, the date 21 or 20.
Provided they succeed in the writ petition. They are proceeding on the premise,
Succeeding in a writ petition.
provided they are,
Try to understand, if we adjudicate the case on merits,
yes,
lot of heads will roll. That's the only issue which is bothering us. Because nearly 30,000 appointments will have to be set aside. In the sense, again, entire exercise has to be redrawn as per the merit of the candidates, irrespective of 30, 70 and all this. You are right. This is only a preliminary hearing. We have only heard petitioners. Naturally, in legal profession, when we read a petitioner's affidavit, oh, we feel, oh, such an excellent case. The moment we read counter, our half of our confidence levels are down. So these are all things. So we are expressing this opinion
so comparative hardship.
after hearing the only petitioner's counsel's argument. When we hear you, you must argue in such a way the theory of petitioners, right?
The comparative hardship also has to be considered.
yes.
The question
Where
of
the-
parity and equity also comes
Where the,
for those persons who have worked for 15 years.
that is what I am saying. They are more than 30,000 compared to few hundreds of the petitioners in these two writ petitions.
But what to do? We were, case is remanded for us to adjudicate the case on merit.
But if they demonstrate that 28 is absolutely illegal and unconstitutional, perhaps your lordship may have to interfere.
Correct, that's what.
But yes, it is only in that situation, my lord, that would arise. And also consider the fact about the timing, having participated, they are fully aware of 28, they keep quiet, they participate, and after 8 months, they file a writ petition.
That's the reason, sir.
Yes.
Right or wrong, we have also considered, and as a human problem, you have also come forward, resolve their issues to limited extent of providing them contract employment.
Yes, yes.
The only issue is you'll have to re-examine the case and consider their cases for regularization before we passing any order. That would be a very good gesture of state government, because you being a state have to be. So when do you want, both of you?
15th would be fine.
15th of
Next Wednesday,
next week. Next week. Or Thursday, it's up to you.
no, Thursday I have a personal leave.
Very
15th should be fine.
Are they all put together? If they are likely to, in all the cases, roughly around 1800, 1500, 1800. Both states put together. How much is yours? You also get that inside. Number of petitioners. And huh? 219.
They have already identified and.
But I think they are not petitioners here. All to one, they are not petitioners here.
So now 219 has been informed.
Judgment has to be only in rem only. It can't
Yes,
be
yes.
personal. It can't be in personal. That's the point. If 28 is liable to be set aside, it has to be set aside in rem, not in personal.
2193 would be figure of the another.
What would be the cost on the state exchequer if all these posts 1800 plus 200 are created, or if there is any opportunity by the state? What is the financial, because
No backwards. There's no cost involved. In fact, we have incurred the cost of litigation.
No, both states, just listen. It's not that you don't require teachers. You require teachers, right to education, that now that compulsory education, right to education has also come and all those things. It's an ongoing process.
Pavitra,
So it's not that you don't require teachers. That's a fine.
It's not the case that we don't require. In fact, the process of directing to find the seniority.
Right or wrong, sir, just listen. These persons have been fighting for their rights from past more than 1.5 decades. Correct? And if you recruit them, You did not even continue for 30 years. They'll be retiring in just 4 or 5 years. That's it.
Your lordship has also.
If you appoint a 20-year-old teacher, perhaps you have to continue for next 30 years. If you appoint this person, they'll be in a better way to teach with their legal experience.
That is what has been held in a 3 judges bench in chairman, managing director, where they said there was a contesting, 2 contenders. One, he fought the case for 17 years and one was sitting on the wall. Then principle of acquiescence was brought into picture. In the Supreme Court, a 3 judges bench has said, because he has been contesting tooth and nail for 17 years, he should be given a job. So if they are working here and they have been contesting, that same principle of parity applies.
Yes, right. Next Wednesday. Thursday.
Wednesday,
Oh, Wednesday, sorry.
apologies. 15.
Returning office and I said, school teacher,
Yes.
Item number 10, P. P.R.K. Prasad, speaker from.
On the other side. I think it also.
2:30.
I've got so much of having. Sorry.
Madam. Previous stuff.
Sixteen, Srinivas Murthy Chirala.
Post after 2 weeks.
17, V. Uma Devi.
Short pass of advocate general is coming. I have informed him, short pass.
What is the case, madam?
It's a case of premature retirement was challenged by the petitioner, my lord. And that order has been suspended by the learner since.
Interlocutory order. Okay.
Short
Password.
pass of-
18 and adjourn.
No difficulty procedure for password.
19, V. Ravindra Babu, G. Vivekanand.
Yes. Ready? Ready? First after 2 weeks. Next.
Twenty, C. Raghu, Vincent Rafi.
Where is Raghu?
Actually, that there is another.
First after 2 weeks. Next.
Case 606 of 2019. Same judgment.
उसके साथ connected के साथ right. Start password बुलाइए.
Item 17, V. Uma Devi, Abhish Narayan Sanghi.
This order, this appeal is filed against the order passed. The remit single is dated 13/10/2023. Wherein, my lord, this is a petitioner in the writ petition responded to before lordship was terminated on subsequent to the procedure under premature retirement scheme, my lord. And it was argued on whether it is punitive or simpliciter. On that point, my lord, the findings were given in our favor. But on the point that whether it retrospective, this scheme as amended in the year 2022 is retrospective or not. My lord, your lordship will find it page number 50 of the impugned order. After bottom para, my lord, page number 50, my lord. After order begins at 47 minutes, the relevant portion it is.
First, tell us the facts too.
Facts minute, she was retired. She was prematurely retired on 30/9/2023. Pursuant to giving effect to this scheme introduced by the management that was in consonance with the scheme issued in 1976 onwards. The premature retirement scheme had been there. But as for the scheme, my lord, your lordship may kindly see the scheme. I find it page number 70, my lord. It begins at 60I, 14th October 2022.
It's only,
That's
that's only, one
number
minute.
70, my lord.
That's only the interlocutor. Go and file vacate stay.
My lord, we will file. My lord, this adjudication as good as final adjudication, my lord, without there being a counter.
Still you are entitled to file vacate stay.
That's true, my lord. My lord, meanwhile,
When
your
you,
lordship may kindly see.
when you agree with the bench, you know the consequences.
My lord, your lordship may please to suspend, my lord, this order, and we will go back to the letter single judge and file vacate stay petition because
suspension vacate stay
because once this legal proposition, your lordship may kindly see.
Once we suspend, where's the question?
Yes,
of
the
vacation?
order
You are
is
able to-
blatant.
One minute.
That's true.
Once we suspend, where's the question of vacation?
Will activate this order under challenge before the letter single judge.
Okay, let us
Is
see
a
just
termination.
1 minute. With this 39/2023 at which page?
My lord, that is at 64.
1 minute.
$64 million, 13/9/2023, she was terminated for her poor performance appraisal report. Million. You were appointed on 27/5/1992 as assistant engineer Aero in grade 1 at Hall, Hindustan Aeronautics Limited, Hyderabad, and posted to SLRDC Mechanical Design Department. Presently, you are senior manager design.
So you are alleging poor performance.
Yes, but
Correct.
for past 5 years.
1 minute. Was
Yes, for the performance
1 minute.
appraisal.
1 minute. Was she informed about her poor performance at
Every time screening committee time and again constituted, and she was informed and even offered explanation also, saying that these are the grading marks he could secure poor 70 below. Under the prevailing scheme, the scheme is like this. Under the prevailing scheme of HL, employees premature retirement scheme introduced by Procedural so and so 5/4/2016, as amended from time to time. Executive who fall in the following categories will be considered for premature retirement. A, those who have completed 15 years of continuous service in the company or attained 45 years of age, as on the last date of September every year, and those who have performance rating of 65 below for three times during the preceding 10 years. Those who have been rated as category B or C in the management review categorization for 3 consecutive times, irrespective of the performance rating during the preceding 3 years. This is relevant to ballot invoking this class. Those who have been imposed with 2 major penalties.
How many years of service? 20 years.
31 years yet.
31 years.
Yes. She had completed 32 years of service.
What is the age of retirement? 60 years.
62 years.
High Court judge.
Yes. It is 60 million.
Less than state government.
Yeah. Now present state equal to state government.
Less than state government.
Yes, well, our performance rating had been awfully bad. Well, at this screening committees had been.
Yes.
Without notice, stigma is without notice has been.
But you are assessed. You are assessed by the committee.
That's what I'm saying, madam. No notice is given. They still contemplate that there should be an alternate employment, that will be considered, and still if person do not find good.
Okay,
Let take it.
which portion of the scheme says that notice should be given and,
Yes, sir.
in
And
fact,
the scheme I will get it at page 71.
70 or 68?
68 is the impure order. Impure scheme 70 onwards, page 71.
No. 68 it starts.
68,
It begins at-
is 70.
Come back to 7,
71.
7, 73, 7, come.
71.
70, come. 73, come. Last 7.
But 71 is the opportunity to be given. 71.
70, okay.
If employee are not able to perform in the existing department, stroke jobs on account of reasons like less workload, job misfit, etc., they may be given an option to move to another department in line with the organizational requirement against the return tax concern before being considered under this scheme. Right, this has not been followed. Right, second aspect, if the lordship, you said that is 70, right? Is 70.
Yes.
Let B says that if your rank is below 65, let I am above 80.
No.
So far as
1 minute. 70, which portion of 70 are reading, sir?
let those who have performance rating of 65 and below.
Where you are reading, that's what you are asking.
It's 70.
73,
Clause B.
3.1B, right?
Yes, 3.1B.
Oh, yes.
Those who have performance rating of 65 and below for 3 times during the preceding 10 years. In respect of working, the PAR criteria for consideration under this scheme would be below 50 for 3 times during the preceding 10 years. But I am rating above 80, 85. So this clause has no application.
Okay, 1 minute. They have considered because your rating is 65 and below, and for 1 minute. We had the advantage of looking into the order. That's the reason we are telling you. They have applied rating of 65 and below for a period of 5 years instead of 10 years. Order says 5 years.
Or even if they take it 10 years, it is more than 80. They have used against me the next clause. Those who have been rated at category B or C. This was introduced for the first time in 2022, which is that fairly learned single judge interpret saying that the scheme itself is not applicable to me. May I just read for my benefit?
From where do you, 1 minute, this or when it has been introduced, from where do you get that?
14th October, page 70 on the top, you also will get it.
Okay.
14th October 2022. So this can be made applicable only
After 3 years.
3 years. And they have used this against me now. So nothing was communicated to me so far as this category is concerned. Because this came into force only on 14th October 2022.
So according to you, 3 years must commence from 14/10/2022.
Restrictions or any guidelines or policy is only prospective in nature. The learned single judge came to a finding that this scheme itself is not applicable to me because I do not fall in any other categories. All rating is above 80. So far as petition is concerned. That is the reason why it was contended.
1 minute.
It's a mathematics.
1 minute. 1 minute. For this coverage, 3.1 to act, there is a note. Note has to be followed according to you. Correct? Without reading note, it is not complete according to you. Right? Yes.
This class might be introduced in Form 14/10/2022, but the fact remains, we have taken into account entire record. That is also, Milad, your Lordship may kindly.
No, 1 minute. You must have taken entire record into account.
Yes.
Come back to page number 70, 3.1.B, or those have rated as category B and C in the management review categorization MRC for 3 consecutive times, irrespective of the performance rating during the preceding 3 years. This clause you have invoked.
Yes.
This clause was introduced on 14/10/2022.
Yes.
So you could not have acted on 14/10/2022 without completing 3 years of service from 14/10. Right? That's the point.
Milad, yes.
You can have any case, right?
Thank you.
Scheme was introduced in two thousand
మీకు
sixteen.
లేదండి కేసు నోట్ చదవాలి కదా మీరు నోట్ చదవండి.
Note your lordship may kind 6.3 at page number 72.
71 అండి.
72 your lordship may kind.
71 నోట్ చదవండి.
70, if employees are not able to perform in the existing department shops on account of reason like less workload, job misfit, they may be given an option to move to another department, shop in line with the organizational requirement against a written consent before being considered under this scheme.
సో ఇది ఆప్షన్ వేరే ఆప్షన్ డిపార్ట్మెంట్ కి షాప్ పోయేదండి.
We have given option.
వేర్ ఇస్ దట్ ఆప్షన్?
Yes. Millard, I'd single bench given as an opportunity to file a counter.
మినిట్ మీరు చెప్పండి సార్.
Yes,
ఆప్షన్
option was given.
Yes, sir. Thank you.
It does. Yes, option was given and she was sent to the Kerala.
ఎక్కడ ఉంది అది చూడండి.
That is. I did given opportunity to file counter, Millard.
We have filed a writ of appeal. The opportunity was there with you. It's a question of what is this kind of argument you are not able to understand?
Yes.
You have filed a writ of appeal and you have not filed a
Your
document.
lordship may meanwhile, your lordship.
No, meanwhile, that is only point.
Your lordship may kindly also see the note 6.3.
ఇది ఫస్ట్ హర్డల్ క్లియర్ కావాలి నోట్. దాని తర్వాత నెక్స్ట్ పాయింట్
Option.
ఫైల్
Has
దట్
not
ఆప్షన్.
exercised the right.
File that option. Post after 2 weeks. Notice before admission. Right.
2 weeks.
Yes.
We will punish.
Why all this? Advocate General, learned counsel, go and file vacate stay petition.
Law proposition led by the honor, that is there. Always that right going to be reserved by the parties to.
In the guise of 1 minute, in the guise of this writ of appeal, you will not implement that order. Well, we know that.
That's
kind
true.
of right.
That's humility.
That's
why appeal.
sir. What is
The question, your lordships are well aware.
No, we are not
The
aware.
objects of the scheme of premature retirement of scheme,
That is
which
has
is
to be
neither
followed.
punitive nor a.
1 minute, sir. That note has come on 22nd October 2022. Without expiry of 3 years, you could not have applied this scheme at all. We have heard you know, sir. I will understand. And the person just better withdraw this. Go and file a vacancy application. In 2 weeks, it will be adjudicated. That would be better order.
That your lordship may make an observation within 15 days, it may be.
Correct. Counsel for the petitioner, appellant seeks permission to withdraw the writ appeal with the liberty to pursue his remedies in accordance with law by way of filing a vacancy application. It is needless to say, if the appellants file vacancy application in the writ petition, the learned single judge shall make an endeavor to decide the vacancy application as early as possible.
Meanwhile.
Preferably within a period of 6 weeks, right? Thank you. అయిపోయింది ఇంకేం మీరు కూడా కన్విన్స్ అయిపోయారు కేసు లేదని మీకు. థ్యాంక్ యూ. నెక్స్ట్ నేను ఒక జేఎన్టీ కేసుకి వస్తాను రావటం లేదు.
That is what my friend is reminding while at the duties of my preoccupation where I am not in.
That should not affect the justice కదండి. You are a busy person. You are a very busy person, very learned person.
I have to attend the sections which comes from the higher ups.
Correct, sir. You are a learned person. You are entitled to be occupied always. That's a different thing. It's a.
I'm sorry, I beg your lordship pardon me. This matter may be taken at on Monday.
Today is this date. ఉందా ఇవాళ?
Yes, that is the.
41 at the request of learned additional advocate general. Post on?
But Monday.
Monday is the holiday.
Tuesday.
Monday week. Monday
Week after. Week after.
Next Wednesday I'll give it. 41. Yes.
One did you change the? He asked me the
Post after 2 weeks. Next.
DB Chaitanya, same. 23 is Mukunda Reddy Ravi.
Who is your other side, sir?
Despite of the publication, no one is there. Why?
Must be watching. When sitting.
Short legal point because they can consider.
Let other side come.
Despite of the publication and so many notices. If you are watching that, no one will appear.
Post after 2 weeks, right? Take.
24 Saraswati Harsha.
Represent Harsham. It's an update file. How to file? That's a delay. So they talk. 2 weeks.
Post after 2 weeks, next.
Right.
Imran Khan.
On the last occasion, settlement was taken in advance and I requested that we posted finally. It's a appeal of a senior, it's a appeal where the senior secretary that responded in advance. Approximately 85+ years in advance. APSFC sold his property, did not give it back, whatever the same proceeds are there, Malars. He filed a suit and decree. Against which had Achilles part, Malars.
So, SFC has filed appeal.
Yes.
It's an institution, you must get ready.
Yes.
When you will get ready? At the request of appellant, as a last indulgence, case is adjourned by 2 weeks, right?
Thank you.
But suits are not maintainable, I think, no? Section 29.
Balance option amount with us.
The Act itself provides for a remedy. One need not go to the suit, I think. Suits are bad,
That is for recovery against any loan or any amount.
but still,
It was considered with us. Considered. In fact, repetition, the mode of action and everything was also challenged with us. That was held to be valid.
okay, right, next. Next.
Observation is the repetition to file a suit.
So that observation will confer jurisdiction. What is, you must argue the legal point.
Legal point also is there with us. It was
Don't say this, High Court has said your suit is maintainable.
recovery of excess amount.
Has the court dealt with that jurisdiction issue?
Issue will also be there.
Okay, we'll.
Right.
Twenty-six to 28 are adjourned, 29 is Sabha.
Then nobody has taken adjournment. Right, 27 kilo. 26.
27.
Then 1 minute.
26 years.
26, somebody has asked adjournment.
28 also. 28 also they have taken it.
Same thing happened last week.
They said they have informed, sir. What to do?
Again, 1 of 23 are filed, rejected the 1 by 27, 6, 20.
Post tomorrow, 26 to consume it.
Tuesday.
Tuesday. 26 Tuesday.
Okay.
27 July.
Twenty-seven, you shall be given law, other no one lie.
Who is your other side?
And
Who is your other side? Serve the papers on Wednesday. Next.
Twenty-eight is adjourned, 29.
Post after 2 weeks. Next.
30 the small firm.
Yes. Post after 2 weeks. Next. I get 2 of 2023 for the reason stated therein it is ordered. वो लिखना पड़ा it should, what is that IA?
Trial system.
And some date has to be given. In which the local newspaper officer जरूरत नहीं है. Okay, right, ordered. చెప్పాల్సి వస్తుందా?
Into local newspapers which are wide circulation, only I mean, or natural language.
The counsel for the appellant is permitted to take out substituted service in two leading newspapers. One published in vernacular language and another in English newspapers. Post after 4 weeks, right? And produce the, and file proof of taking out that such and proof of filing, proof of substituting the service by way of a proof before this honorable court. Next.
Muttapalli Savitri Ashok, TSHC.
But I did represent Harsham.
Ready?
Let the applicants contrast. Counter.
Ready?
Yes. Let the applicants before Lordship are the daughter-in-law and the granddaughter of respondents 1 and 2. After the death of their son, both of them are kept outside the house and they are alienating the properties. So in such situation, a suit for partition and separate possession was filed. And they have also demonstrated before the trial court by showing the photographs. Both of them went to registrar office to alienate the property. At that stage, when injunction was sought, the court below did ordered urgent notice.
And dismissed your injunction. Suit for partition.
Yes, no, earlier only ordered injunction, ordered notice. While ordering notice, Leonard Judge said, well, no, it is only dispute between father-in-law and daughter-in-law and granddaughter, therefore urgent notice. So therefore, questioning that order, we filed revision before the Assembly Court in page number 107.
Correct, that is now dismissed your IL.
Yes, now dismissed.
Right.
So the same officer.
What do you say?
So status quo was granted.
1 minute again, sir.
Yes.
Status quo, there is no document tied to substantive that the properties are not ancestral properties, that was the other way.
1 minute, sir, 1 minute, sir. Somebody has filed a suit for partition, claiming to be your daughter-in-law and granddaughter.
Yes.
Yeah. Their first appellant's husband has expired, who admittedly happens to be your son, right? Suppose if you sell away the entire property, what remains in the partition suit? Please answer that.
No partition is not only for the ancestral property, it's not for the self-employed property. No document, even in the present CMM, no documents.
What is the suit schedule property?
Suit schedule property, there are several properties. May appreciate the.
So you could establish it before the court below, where you have a counter saying that they're all self-acquired property. Where is the finding of, where is it?
Page number 13.
Read it.
I just come on page number 14, my lord, para number 16. On careful consideration and analysis, the entire method on record, it is clear that the plain rescheduled property was already alienated on so-and-so and its registration was made on so-and-so. The petitions for entailing the alleged fertilizers and mortgage bank were dismissed by this court, observing that the plaintiffs can take help of doctrine of misconduct and the plaintiffs did not place before the court any prima facie material to show that the plain scheduled properties are ancestor mature properties. All the documents filed by the plaintiffs are in favor of A1, except some state certificates in which the name of the father of the plaintiff is. In the absence of any material to show that the properties are ancestral properties, and the share certificates and the movable properties were acquired with the income from ancestral properties, it cannot be said that there is a prima facie case in favor of the plaintiffs. There is also no balance of convenience.
What is the status of that first appellant's husband? What was the status of that first appellant husband who has expired?
He was doing business. He was doing with the family properties in business. He was associating with the father, and father is a doctor, running a hospital. And because he is not educated like other sons, he is the one who is developing these properties. Father is a doctor.
get instructions, because it's your moral responsibility also to take
That
care
will
of your, 1 minute, agandi sir. It's your moral responsibility also to take care of your daughter-in-law and granddaughter. Kada. When more so, unfortunately, your son has expired, no? So their interests are, first be a human being, get instruction, then we will get it. Fair enough. Forget about law. First, let us all be, first, let us all be first human beings, then the question of law. Thank you very much.
How many children are there? How many children are there?
For that, first defendant has got how many children is the question being posed by the bench. Right.
So there is, they are 80 years. Property is 25 crores, no?
80 years, so not self-employed property.
Oh, there it is, but something can be given, isn't it?
After all, it is only correct. However, you may dislike your daughter-in-law, but still, granddaughter is there. So 1 minute, granddaughter is definitely
And
belongs to the
she is also doctor pursuing PG NEET. So she's in the line.
You must understand.
Is also a doctor.
Correct,
That's the reason we are telling.
Post after 2 weeks. Don't try to precipitate things.
I will.
32 and 33 के दुर्गा सत्यार
I filed a proof yesterday,
What is the case?
that the petitioner is the defendant and he is the producer of a film contract. Now, the plaintiff filed a suit.
It starts with K, not C. That's the problem.
The court below that directed furnish security in 48 hours. But actually, the document filed there are court, he is not a partner, and the name of the
So what is the direction given by the court?
court is directed to furnish security for the suit amount in 48 hours and release was stopped. Then will file an application to relax that. That application is dismissed. On the ground that unless the suit is decided, it can't be taken.
How much security it has directed?
Because he is not a partner, he has not financed.
No, how much is the security?
He doesn't have any money.
Please answer, what is the direction given by the court? Asking you to furnish how much security? 1 crore 61 lakh.
6 lakhs.
1 crore 6 lakhs, 1 crore 6,000. The clarity is not there in the plaint itself. One place, he says 1 crore.
Bring other sets, sir. We can.
I thought what may have it next week.
Next Thursday.
Much of it. I filed the proof also. That is fine.
You know him, you just inform him. Sir.
Nobody filed.
No, not Wakalat, sir. You know as a person, no, who has filed and all this.
He won't come with that because the documents are full.
Next. Next.
34 Mohammed Bashir is asked.
Your lordship,
The dedication of one.
may I represent your lordships,
Post after 2 weeks.
representing for the petitioner, your lordships.
Yes, madam.
It's a
Not
CMA,
able to hear.
your lordships, your lordships.
Make a
I'm
WhatsApp call then.
I'm representing the petitioner, your lordships. I'm representing the petitioner. Your lordships had a opportunity to hear this matter, your
Well,
lordships.
senior. Your senior. Call her on WhatsApp call.
Your lordships,
You can turn here and call. Nowadays everything is permissible.
your lordships,
Not receiving the calls.
your lordships can hear me? Your lordships,
Area is not busy.
your lordships can hear me? Your lordships, I can hear you. Your lordships? Your lordships? Hello, hello, hello? Your lordships,
Yes.
hello? Hello, your lordships, your lordships.
Just a minute, ma'am, just a minute.
Hear your lordships, I can hear.
and see your lordship as well.
Thank you. But you argue from your WhatsApp call, right?
Yes, your lordships.
I apologize.
No issues.
Yes, your lordships, I'm grateful, your lordships.
Other side have not been served with the papers, it seems.
Your lordships, the Bakalas has been, your lordships and
Another respondent has not
has refused
refused
with
with
what
what is showing up, your lordship.
That is right. What's your name, sir? Srinivas, appearing for? For both the respondents. Serve the papers, we'll take it up next week, madam.
your lordships may take it up earlier, your lordships,
Because there is a danger of an alien.
property.
Post next Wednesday.
Yes.
Serve the copies next Wednesday.
Yes, your lordship. Yes, your lordship.
Ask your colleague to take this phone.
Yes.
Adjourn the case. Okay. Post after 2 weeks. You are not getting that WhatsApp call? Both we are not able to hear, no? Both.
We can hear you, my lord.
Cannot.
Can't use computer for audio. Can't use computer for audio. No speaker found.
Ah, there's some problem there.
Sudhir sir.
Yes, Sudhir. Yes, Sudhir.
Can you hear me, no? Now?
Give it, judge sabko de do, Praveen.
Can you hear me, my lord?
My lord,
There seems to be some network issue.
Yes.
My lord, as the lordship rightly said, my lord, matter can be posted some other time.
Okay, post after 2 weeks.
Matter of removal.
Yes. Carefully, जिसका उसको ही दो.
38 jail Sudhir Kari Praveen Kumar.
Yes, Anurag. You can speak, I think, not through phone. Post after 2 weeks, Anurag. Right, next.
39 K Udays for Johnson.
Your lordships, in this matter, I appear for the respondents, your lordships. Your lordships, earlier, senior counsel for the appellants and the advocate general had argued this matter at length.
Section 77 of
Yes, your
Arbitration
lordships.
Statement.
Comes down to that one single point, your lordships.
APCOM.
Your lordship,
Post after
earlier,
2 weeks.
40 and 41 are adjourned. Chapter 12, 43. Ramara Mounty, Chimasita Reddy, K. Vidya Prasad.
What is the case, sir? We'll hear after Diwali, sir. Post after 2 weeks. Both here. Next.
44, Sifullah Sharif, Panchayat Raj.
cut in pension, no? Cut in pension,
Yes.
70%.
LRs now 2023, LRs are we not.
They're aged about 50, 45, same thing, no, LR? Post after 2 weeks, right, next. Huh? What's that? And we'll see next, post after.
45 is Reddy, 46C Vani Reddy, Ravindra Bharati,
Roster, madam. 7-point roster. Post after 2 weeks.
47 Vani Praveen Kumar, Kartik Krishnan,
Post after 2 weeks, next.
48 Welfare Associates, K. Satyanath Smriti, N. M. Mujli,
Yes.
Kaushal, Senior and Company, the professional side of an other.
Post after 2 weeks. 2 weeks, next.
Welfare Associates, Typical Revenue,
Post after 2 weeks.
51 is Savi Kumar, the mother of Dow.
How is Ravi Kumar, madam? Has he recovered?
From the page for the senior MBA students who are still registered in the matter. My but in this appeal, they have to also file declaration of majority reference to the respondents. I'm filing the material booklets today along with the.
Post after 2 weeks. Post after 2 weeks.
54 for appeals, where Archer appeal.
Yes, sir.
Covered matter can be disposed of.
When the matter is taken up for hearing, the government pleader appearing for the appellant shall inform the court that the issue raised in the present petition is clearly covered by judgment rendered by this honorable court in LAAS number 1074 of 2011.
In asking from 6 rupees per square meter to 8 rupees per square meter.
Dated 31/7/2017, wherein a division bench of this honorable court was pleased to enhance the compensation
The fixed by the reference court has been confirmed.
as confirm the enhancement as ordered by the court below. And the court below has enhanced the compensation from ₹6 to 11 rupees 40 paisa
One
per
correction.
square meter.
One correction, my lordship, to lordship's comment. In this particular case, 8 rupees. In that particular case, 11 rupees. So 8 rupees has to be confirmed in this lower court.
First after 2 weeks. What is? How can we confirm 11 rupees, 8 rupees?
No, no, no.
When we are following that judgment, we must follow it 11 rupees only.
Same project. But in this particular notification, other appeals were not filed.
No, no,
In
next,
this
first
case,
after.
8 rupees has been confirmed. In that particular case, 11 rupees has been
No,
confirmed.
they left it.
Confirmation from the same, then it will be difficult. Discrimination.
It amounts to. Now, in your appeal, it can't be enhanced also.
No, no, my lord. In that also, cross objection filed. Here, no cross objection has been filed.
Sir, just because cross objection has not been filed,
No,
you cannot say that it should be confined
the
here.
reference court, that the land to land is different, village to village is different. That is far away village.
Any of Raj Reddy is there, no, let him come and we'll see.
Because you lordship to inform me about the covered matters may be.
May
So that we
please
can
call-
dispose of.
Correct, GB Garu, but still you must understand, we can't deviate from the order which you are trying to rely. It is 11 rupees something, no?
In this particular case,
3 rupees 40. and
court come to
50.
conclusion, reference court come to conclusion, 8 rupees. The same has to be confirmed.
We చెప్పండి, we are not opposing this. We let the court below order be confirmed and we close like this. That way we can do. Counsel for the one and Peter as in. Huh? You want us to fix the bench in a this thing. And when it comes to your submission, you're asking us not to record.
Rajareddy has got one junior.
If he's agreeing for 8 rupees, we don't mind.
I will take it like this.
I'll put it like this, sir. A division bench judgment enhanced from compensation from 6 rupees to 11 rupees 40 paisa or something.
Yes, sir.
You are saying that it is covered by the judgment. You are asking us to close this case. Then we'll have to necessarily give a finding that it has been enhanced from 6 rupees to 11 rupees 40 paisa in that case. Same, by following the same, this is also liable to be dismissed. That observation will have to take.
That is in case if the land council has filed a cross appeal before this honorable court. Here, 6 rupees to 8 rupees, we have challenged. Government has challenged.
Correct. Next. Post after 2. That was in 2017. We are in, after 5 years, you are saying it is covered any. Then this 5 years also enhancement has to be there, no?
Right. Now when we are receiving these cases, we are picking out as per the lordship direction which are
Next.
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 Only last year I have taken the challenge.
Yes. Post after 2 weeks, right? That CRPF enhanced. Latur earthquake, right? Next.
Satish Kumar, lead law, Durga Prasad.
Post after 2 weeks.
P. Sundarao, P. Lakshma Reddy.
2 weeks.
59, Deepak Bhattacharya, J. Sudhir.
2 weeks.
60, J. Sudhir, A. Krishna Raju.
2 weeks.
61, Karthik Madano, Gadi Praveen Kumar.
Post after 2 weeks.
62 and 63, J. Sudhir, R. Vinod Reddy, G. Arun Kumar.
Post after 2 weeks.
64 is adjourned, 65, J. Sudhir, Gadi Praveen Kumar.
2 weeks.
66, Dr. K. Lakshmi Narasimha, Gadi Praveen Kumar.
2 weeks.
67, B.K. Raman, Sudhir Kumar.
Yes, Raghavan, what is the case?
Thank you, Rashid. Very fast. You know, of it, anyone retired. You want to, Dental department. Well, working in GPPO, they were tested under 2001, 89.
What is the punishment?
Because of filing and refusal of any sanction and penalty. The
Entire pension, 100% cut in pension.
pension.
What is the allegation?
In which is found, the actor takes the 2,80,837. And the criminal found is 1,98,000, so 019. But the small amount.
The Muslim makes it a trade amount.
Come back to page number 12 of your affidavit. Your case is, it's not disproportionate, it is redone. Correct?
Yeah, so because.
No, 1 minute, you are saying it's redone. No? No, you are saying it is Sridhan. For Muslims, there is Sridhan.
Every lady is a Muslim, or Hindu, or Christian.
No, no, no. You can't argue something contrary to your own personal law. Yeah, anything contrary to personal law, you cannot argue like this. You cannot become convenience.
That is a ground which has been raised, sir. That is a ground.
Huh? No, no. Sridhan will not be there. There won't be concept. 1 minute, there won't be any concept of Sridhan. Correct?
Separate concept at all.
Huh?
People cooperate and all those things.
Correct. You are
Separate.
trying to import Hindu law into this. No, not diamond. That's your government, right? What is? Come back to page number 12.
No number 8.
Oh.
People pay to calculate height and length. Our five thought a midnight cloth of gold and 25 cloth of silver from a metal robe by way of gift.
How can you get that Sridhan? Huh? No, no, cannot be. Anyhow, he has expired, nothing survives. Which goes. What is the status of LR?
Small time business plan. The during a case have taken general value and transferred as profit also. Look, it is constructed by the himself.
First after 2 weeks, right? 2 weeks. Yes.
We have filed letter which is for the number 3, 4, and 5.
First after 2 weeks, next.
Like Mohammed Fakir saying this is for revenue.
First after 2 weeks.
70 Rajul, 71 Gari Praveen Kumar, SR Shampoo.
Now, these be preserved for orders.
2 weeks.
72 Karim Murali Krishna, this is for revenue.
My lord, have it
2
after
weeks.
2 weeks, my lord.
73 K Rajlakshmi, this is the services 1.
2 weeks.
74 and 75 KRP Prasad, Gari Praveen Kumar, we recruit also now. 74 KRP Prasad, Gari Praveen Kumar.
Pass over.
Update instructions in the last page is good by what to please to observe. With cumulative without cumulative. That was addition is came from the get instructions on it.
First after 2 weeks.
75 KRP Prasad, B Lakshmi Prasanna.
It's not the classification, this is where the failure stopped for over 4 hours and the person was removed from service.
Person who stopped for 2 hours because of headache. He was stoppage of.
And first person, prediction itself, when she was already not taking any because then it is not been completed his duty. Whereas after first election, that completed more than 10 hours. And we don't even ask for the behavior very morning, sudden headache like it was asked. Because of the health section, the investigation. That is it.
When you have stopped the train, which year? Orders of removal are dated. By which time, how many years of service he has put in? By which time, how many years of service he has put in? When he was appointed? What, Aishwarya? Ready? Not ready? Pass over.
MB Rama Rao.
Yes, post after 2 weeks.
77 and 78. KRK Prasad B. Narasimha Sharma, Bharat Praveen Kumar.
Post after 2 weeks.
79 and 80 Satyanarayana Pratapalli. Services from SV Indira.
Yes. SV Indra, yes, what's the case? Which item we have called, madam?
79 and 80 Satyanarayana.
17 and 80 are connected.
These minor penalty subsequently another case same customer removed.
You are appearing.
80 I am appealing, madam, but then the first punishment will be given imposed to me with the removal.
What about 79?
Oh, yeah, 150%. Oh, yeah.
80. 79. 79. Same person. Yeah. 1 minute.
7 years of incident, inquiry officer was appointed. Fixing on the judgment.
What is that thing I believe? I am appealing in the next matter, said it's a question of removal.
What is the first case of punishment? 50% of what?
60,000 rupees. For the stoppage of stocks, the punishment was imposed.
Stocks of what?
Recovery of 50%. The stoppage of 2 increments, not cumulative effect. Besides recovery, it's the punishment.
So, what is the designation? That some MLS points go down verification, same thing. MLS points.
Even though you charge sheet or machine number of 37,1997. After 7 years, we got a legal officer appointed. What standard I am giving to this?
Let Shiva argue the case because he is challenging the dismissal order. Yes, dear.
Madam, there is a case in red matter. There was a class played in respect of a person, which was not against the petitioner at all.
But you were ultimately.
And senior assistant says it was selected on my behalf. The tribunal for disciplinary proceedings proceeded with the matter. It came to a conclusion that it was guilty. The tribunal reached that and says that the punishment is perfectly valid.
Your case is also referred to TDP. Your case.
Mine is referred on, mine is by the TDP only.
Okay.
Now,
Senior assistant, his case is also referred to TDP.
but my case, at the relevant point of time, the officer.
Correct, sir. Whether TDP has inquired in respect of petitioner as well as senior assistant or only you
Two separate cases were there.
before the TDP.
Yes.
So, did TDP let off that person, senior assistant?
Dismissed and we filed a ruling. What happened thereafter?
Right. What is the amount you have demanded?
What is the amount that was alleged? 1,000. I have not demanded is my case number. If I had demanded, I would not have given a law before the lawsuit at all. The allegation was that.
How much is the amount? How much is the amount? How much is the amount? Okay, then.
Has submitted report. I didn't see the report,
one.
You're arguing 306, same thing?
No, madam, 111011 of 2011.
Page number?
One, madam. Para 7, he says, what is the point for consideration? And this is what it says, the crux of the prosecution, that's how it begins. The crux of the prosecution witness number 3, that is the daughter-in-law of PW1, is running fair trade shop in Koheda for so and so years. She submitted application for renewal of subgrades and kerosene, etc. Required challenge for so and so. She met MRO for times. He had made her to go around rounds in the office on the same ground or the other, on some ground or the other. And for instance, her father-in-law PW1 went to MRO's office and met the MRO when he asked demand 1,500 rupees for renewing licenses in the name of so and so. PW1 went around for 2 or 3 days thereafter. However, reiterated his earlier demand. However, PW1 expressed his inability to pay the same. However, MRO did not keep to his request. 10 days thereafter, PW1 paid rupees 1,500 to MRO. He accepted the same. He in turn paid rupees 1,500 to his office junior assistant, Mr. Balaya, the charge officer in TEC number 84 of 2004, on the file of this tribunal and directed him to renew so and so. He identified the signatures, etc. Complaint in 164 statement. Now kindly see, the finding of the guilt is based on what? That's found, my lord, at page number 55.
Yes.
Page 55, my lord. So the time for consideration has been given. This is what we would say. At page number 55. Indisputably, exhibit P2 is a document. P2 is a document. Is a complaint being the foremost document. PW1, the author of so admitted before the court in the stage of cross-examination by the learned AGC, meaning that he became hostile. And that is the reason why prosecution cross-examination. That he lost the exhibit.
No, 1 minute. 1 minute. Para 12 read. We're not able to understand. What is it you're trying to project?
Indisputably, exhibit P2 is being the foremost document. P2 is a complaint. As the list of documents your lordship will get at page 58.
Read further, however, PW1.
However, PW1 author of exhibit P2 admitted before the court during the stage of cross-examination by the learned AGC, he launched exhibit P2 to ACB police.
Correct. Where is the question of hostile? He has supported.
It's here that. Now it has been examined, he writes. Now kindly see page number 14. I mean, para 14 at page 56. It must, however, be observed that PW1 admitted that he gave a statement under 161 CRPC, exhibit P3 before ACB police, and gave a statement before the judge at so. This means that even in the absence of consistent evidence before this court, there are exhibit P3 and P4 before statements before PW1. In exhibit P4, that is 164 statement, it is stated that PW demanded trade drive or so. Exhibit P3 161 statement, if really the CO had not made any demand for drive, PW1 would not have stated in exhibit C, P2, P3, P4 that CO made a demand. Merely because PW1 turned hostile before the court, it cannot be said in the case of the earlier documents P2, P3, P4. That is complaint 161 and 164 basis, he comes to the conclusion that I am guilty. Whereas the complaint himself turned hostile. And then it's a clear case of no evidence. That is the precise reason we have been saying that it's a purpose finding. Merely because PW1 turned hostile before the court, it cannot be said in the case of the earlier documents P2, P3. If complaint was sufficient to indict a person, every complaint must result in conviction. This seems to be the concept of the learned TDP, which fortunately is not the law.
Not the law, but the practice is all MROs.
But let us not go by the general presumption that police department is MROs. That's not what we are sitting according to the law.
It's a case of dismissal.
It's a case of dismissal. By the time the order is done.
What is the date of dismissal?
That is 9/10, the GO 14/9/2009.
After it.
Please see funny meeting. Permit me to read page 60 for one moment, my lord. What is the application before we inflict a civil death? Zero. Absolute zero. We will forget about all
only narration of fact.
It is,
Say
1 minute.
six.
When he has retired? Or removed? Dismissed? Not removed. Just 1 year before this.
Who was the owner of the Fair Price shop?
PW3.
Counsel, even if there is a hostile, if he has given any statement, if it is corroborated by other witnesses, is that not the principle in jurisprudence, legal jurisprudence?
It's allowed like this. Let us take the complainant has turned hostile. Please go by that situation because my lord, in criminal trial certain things may happen. But merely because the person has turned hostile, it should still be an owner's task for the prosecution to make the corroborative statement. What will happen of hostile of the complainant to the private person? That's not even dealt with in the tribunal order. It only says I have 161, 162. And then the complaint.
This is a deposition of PW3, who is the owner of.
Depositions were not available when I filed it, but now I think I have it, and give them to the
Most after 2 weeks, right? What cases?
Hello. 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 Hello, madam. Hello. Can I, madam?
Lordship, I was reading the implementation order, Millard, volume 1, your Lordship. And today I filed volume 2 also, your Lordship. No, but I'm sorry, because of the urgency, the officials. Page 4 of the volume 1, Millard. Volume 1, because I could not explain on that day. We got that 50% and that clarification. Lordship, page 4, table, your Lordship. Volume 1, page 4. Sanctioned strength of the cadre is 105 Millard. Out of that, number of SC, ST required in the cadre, 15% and 7% is 16 SCs, 8 STs, unreserved is 81. As on that day, page number 4, table, Millard. 16, 8 and 81. That should be the composition. Then number of SCs, STs available in the cadre against SC, ST roster points, that is based on roster, they have been promoted 8, 6, 69 unreserved. Then your Lordship can see shortfall is SCs 8, STs 2, unreserved 12. These were notified in the 2010 selection. No. This is after judgment. Nagaraja to be followed. Nagaraja to be followed. So adequacy was not there because shortfall was there 8, 2 and 12. So therefore they have been notified. Now that is only for that notification, Millard. That notification they challenged it saying that it was contrary to the Nagaraja. It is not contrary to the Nagaraja because 8 vacancies are to be filled under the SC category. No, this was not being placed at that time. It was there in the record, but not placed. Subsequent to the judgment, again, these proceedings have been issued and these proceedings have been placed before the dishonorable court. in earlier contempt case. No, in earlier contempt case. Follow the Nagaraja. This is the exercise, Millard. This is the strength, and based upon this, notification is in order. And lastly, we said. That is so, Millard. They were saying that notifying these vacancies was not in accordance with Nagaraja. And these. Well, again, redrawn and some qualified with this adequacy, Millard. That's why these proceedings have been placed before this honorable court in the earlier contempt proceedings, and that was dealt with it in the contempt order, earlier contempt order. So the second. Not nullified, Millard. Already this honorable court said, consider these proceedings and passed an order that there is no contempt. And now second contempt has been filed. It can't be a review in a contempt matter, or second contempt is not maintainable. Your Lordship kindly take up those proceedings, Millard, that contempt. No, I just your Lordship kindly, kindly go through this contempt order, earlier contempt order, where it has been considered, page 53 to 59 in volume 2. Today I filed it. Earlier also it was there, but now. Yes, Millard. No, that's what I wanted to explain, that SC/ST is available in the cadre, that your Lordship, unreserved category also. In the same table, your Lordship can see. The second one is SC/ST is available in the cadre booked against your points. Unreserved vacancies also SC/ST is available. Yes, ma'am. We are explaining the same table, Millard, 71 and 72. We are explaining the same table. Unreserved quota also, there are SCs and STs. In unreserved, your Lordship can see, in unreserved quota, now as was done now in this selection also, against unreserved quota, SCs have been selected. By so and so respectively shows that there is a shortfall of 8 vacant posts of SCs and 2 posts of SCs in the category of AEN. By filing the SC/ST roster vacancies, we will be fulfilling the required percentage of reservation of SC/STs 15 and 7.5 respectively in these cadres. There is no breach of quota SC/STs respectively. The concept of post-based roster is being followed, which ensures reservations provided SCs. Then even coming to that, again, total SC/STs. Suppose SC/ST getting in merit, SC/ST getting in roster point. Roster point we have given this, and SC/ST is getting in unreserved category. In the table itself is shown. SC/ST available in the cadre booked against UR points. 18 and 4. 18 SCs were there. So therefore that yes. If a person comes under I'm sorry. I'm sorry. Yes. Yes. ఇక్కడ కలపటం లేదు సార్.
Once again, we are reading slowly again for your benefit regarding the frequency of the data collected after retribution order collected in respect of petition also, by private respondents, the OA numbers also, 5.60 percent respectively. Shows.
Your Lordship, can say, no, page 4, Your Lordship may read. Selection to the grade B post AE and DN in the cadre so and so in South Australia for the assessment period from 21/1/10 to 20th June 2012. Cadre particulars as on 21/1/2010. They say that notification was contrary to Nagaraja. Therefore, this could not have been done it. I think I made myself clear. Eight, 2 and 12 million. No, 8 to 12 million, the same thing. SC is 8, ST is 2, 12. This notification was. And in the challenge, modified orders have been issued. No, interfered, that modified order is issued. No, it is. Is that same notification? So, yes, my lord. Yes.
An extra step was given to you to examine the case in terms of the guidelines framed by the can only extend reservation for the CST. Otherwise, for an
Yes.
answer.
Yes.
Now, page 5, Roman 7.1. Regarding adequacy of representation, the meeting issue, data collected in respect of petition number 14.
Yes.
You have collected the data after 2014 again, because you are referring to 2014.
No, sir, pursuant to that order, no, your data, cadre particulars as on 21/1/2010. Your lordship, fourth page, the cadre that is. Sir, ఇక్కడ రాయడం సార్ Roman page 4 million above the table cadre particulars as on 21/1/2010. For that notification, whether you are properly notified or not was the question. For the,
back to page 5.
yes, my lord. The same notification, my lord, in 2010 notification. 10 less, sir. ఇప్పుడు your lordship can see that is 2010 ఉన్న cadre తీసుకుంటున్నాం మేము. We are only dealing. 9942 million. 9942 is our order.
Remember this one is asking. And the time really honored to all wisdom comes. The orders, the fact of English is very information. Not following. Take down the diagram. We even not SCCA, that's it has confirmed order. The further examine.
Conclusion, my lord. Conclusion, my lordship.
Yes. Now,
As the tribunal has merely followed the law laid down by Supreme Court in M. To the extent declared that action in providing decision. The fact, however,
they find themselves
additional revision. The repetitions are about this. Gathering data, that data which is in 5-7.1, the data you are supposed to collect after disposal of the. And forming it opinion on the parameter. But four techniques. Re-event not yet. So that is, you are obligated to collect data after the disposal of the judgment. That is how you have done. At page number 7.5, you are trying to argue a different. Again, you are calling back on notification, cadre particulars as on 21.10.
I am only justifying your lordship. No, your lordship can see, subsequently, the same, if contempt has been filed and the same, your lordship can get. No, your subject, your lordship kindly see, contempt, in this court, contempt orders have been issued, page 86, Page 86, your lordship. No,
This statement which you are being.
I'll place the data as on that day also, Millard. I'll place it. No, the department understood, notification. No, as on that day also, I'll place it before Lordship, Millard, Monday, next Tuesday, working day. I'll place it, Millard, on that day also. Not dangerous, Millard, even as on, even within the two, within the two. No, Millard, within the 2 years also, there was no further recruitment has been taken place. I'll place it as on that day also, Millard. No further recruitment has been taken place after 2010 till today. Deeply obliged. No. My lord, as a senior counsel also, I am bound and duty for me to see that, in fact, these proceedings have been placed. No, these proceedings have. Even no, calculation of adequacy, Millard. No, subject to lordship. That's why I filed all those papers. No, subject, what, your lordship may not have that opinion. Why? Because I've gone through the papers. What I'm saying is a person who got recruitment under the unreserved quota, even though he belongs to SC/ST, will not be counted for that vacancy. No, prima facie, your lordship is having that. I wanted to. I'm not saying that. I can't say that your lordship is only way of thinking and exchange of the views. And ultimately, I have to satisfy your lordships. Otherwise, I have to.
Justification, your lordship wanted to know the three important issues, the other side reply, my lord. How many years of appeal?
Your lordship, 1995 is appointment. 2007, six. He was working as a driver since 2003. He was appointed as a 95 was appointment, but as driver since 2003 as a loco pilot. 61. Page 61.
So the date of appointment, I'm sorry,
Actually, my lord, I'm sorry. No, no.
Page 25. Page 25.
Sometimes if you write more also, courts are taking objection, my lord. Why are you writing all this introduction? Sometimes.
Page 25.
Whatever you write sometimes is.
At page
My lords, I
25.
mentioned in my OM, my lord.
Page 25.
I'm sorry. Applicant appointed as diesel assistant on 13/12/1995, my lord.
Further, there will be the continuation. Before our-
Lordship, because I have lordship passed on the,
Person who stopped at three point forward, he will-
in fact, I'm wrong by saying this person also stopped for 2 hours and 45 minutes, not 4 hours. I was wrong when I submitted it was 4 hours, it's 2 hours and 45 minutes, your lordship. Other person 2 hours, your lordship.
No, 3 hours.
No, your lordship, the thing is that the conduct of this person is that he was informed that there will be no relief arranged. And that other person, your lordship, he was only on medical. No, it was only on the medical ground that person was arranged relief and he was already informed. Yes, your lordship. This person, no, your lordship, he worked for all the 10 hours, your lordship. It's only that on a medical emergency, he asked at that particular time. Lordship.
Well, 8 will 6 hours. Right?
That time. But no, your lordship, here, my submission, your lordship, is only that the conduct of this person, because he was already informed that there will be no relief. He's been informed. Yes. 3 hours.
Person will have for 2.5 hours. in the project.
The other person, 3 hours, 15 minutes. 3 hours, 15 minutes.
Regarding instructions, these 2 points your lordship had asked, and so these 2 points I have got your lordship, and furthermore instructions. One was that whether he was informed about the.
There, my lord, I am only skeptical about one thing. 95 was the appointment date. And the initial removal order is of 2007. Whether he will get any benefits.
So many years.
Actually, my lord, this misconduct is brought into, like, I mean, rule has come subsequent to the incident. That is another important aspect.
But we not consider.
And another thing is, number of times he was arranged relief while he was passing through headquarters. He did not expect that.
License for you to stop the.
But in spite of information, they had done this way, my lord. Back wages, of course, I leave it to your lordship, sometimes 50%, something like that. Or notional benefit also sometimes you. Take instruction.
What is the age of that person?
54 now, he is 54, I believe. 54 now, your lordship.
I don't know, that not same battery. That is fine.
41.
Jobless, my lord, some petty jobs he may be doing.
Subject to medical fitness also.
Yes, ma'am. In any case, they will direct him for medical examination because it is a running cadre. Safety is essential.
On a contract, we are doing it, we are being very specific. Only to one is family.
There is no provision for this cadre, my lord. That is the menial jobs like cleaning, etc. That's all.
Okay, you file a controversy.
Item number 81. Eighty-three guidelines, 83. Ramakrishna Digital Services Fund. 84 Digital Services Fund in Ramakrishna Brown. 85 Digital Services Fund, MB Raja. Yeah, we are representing for the respondents at 5. 86 Shreya Lupita. 87 J. Sidney. Administration. No. It's never that. Yes. 88 Namaskar. Botuluri. Srinadho Nama. 80, 89 and 90 Super Service Fund, Dr. Ravi Kumar. 91 Super Service Fund.
Lata has requested for 4 weeks.
92, I am ready, my lord, for the respondent. My lord, I am for the respondent, Protestarov, ready, my lord.
Right. Like next week.
Next week.
Koteshwara Garu, they're asking next week.
Obliged, my lord, thank you, my lord. Obliged.
Next.
Directed to pay the increment in the year 2011 and 12 your lordships. Facts of the case, your lordships applicants. Your lordships before tribunal, Mr. Acharya has appeared, your lordship. The applicants were working as technical officers, your lordships, in the respondent department. Lordships, as per the Government of India, OMU lordships of 2010 September, your lordships, an increment is being paid to the applicant respondents for the year 2010 and 11, whereas for the year 2011 and 12, it is been rejected basing on the communication issued by the respondent number 1, your lordships, that is ICMR. Saying that your lordships, as it is that OM is been applicable only to the central government employees, whereas the ICMR is the autonomous institution, your lordships, and these are the technical and these are the technical officers, and they are placed in the pay scale of 6,500 to 5,000, 10,500, your lordships, whereas that OM was restricted only to the employees who were in the scale of 5,000 to 9,500. On that ground, your lordships, for the year 2010-11, they have not been paid with that increment. Rejected. Challenge. That sister organization, your lordships, the communications issued by the respondent department clarifying that they are not eligible because they are working as technical officers, as they are getting other benefits like extra allowances like house allowance, phone allowance, and all, your lordships, they are not eligible for this. And also they are not fitting in the scale, your lordships, fixed by the department, your lordships. That papers, due to oversight, I guess your lordships are not filed along with the writ petition. I have filed before the tribunal. I'll file your lordships basing on the letters issued by the respondent. I am obliged to.
Madam, hearing for the contesting response. Well, as directed the opponents 1 to 49. They're all working in the passport office, sir. But they were joined as a casual laborers in the year 1985 to 87. For the
Your lordships, in this matter, both government and as well the affected unofficial respondents have filed writ petitions.
government is the main contesting. Unofficial rates of.
95 and 96
Order.
are connected.
The apprehension that my lord, we will affect our, the order of the tribunals will affect their seniority. That's the simple case, my lord. But they were. But,
For the unofficial respondents, Mr. Suresh Kumar Garu is appearing.
but unofficial respondents, that was taken care. I don't know why they filed the expectation also. In the operative portion of the order. No, no, exactly what time when my friend is saying, that my. It comes family now, but I had to, that synopsis, my lord.
27 Kumar. Lordships. My other colleague is appearing in this matter. I'll. Oh, your lordships, because file is also not there, so I am handicapped with the file. your lordship. My apologies, I am obliged.
Ninety-eight minutes. I find transit locality in this case. Item 98. Petitioner. Yes. Respondent statement. BVL and Sharma. Well, originally BVL and Sharma garu filed a comparing for petition, my lord, WP 6477. I'm sorry, my lord. I'm sorry. Very sorry. After the talk.
98, your lordships may kindly short pass or your lordships, I'll take instead. I have no instructions, your lordships, I'll.
Sorry for the inconvenience first. Petitioner rendered more than 30 years of service, my lord, is past service rendered before the railways department and military, my lord, is not being counted for the purpose of pension, my lord. Total, my lord, 30 years, my lord. My lord, railways, my lord, from 15/11/57 to 1463, my lord.
For respondent 3. Application. No, we are one formal body. Government has to take a decision regarding.
Ramanu garu.
With that,
Yes, we can want to build. No, the matter, but the active natural sense. But the other side is not here. We still also not there.
Advancements. Advancements.
Not here.
102 advancements.
Yes. Can get out. Search.
Then we get those.
Code should not drink. Code doesn't require our permissions.